Senator De Freitas.
Thank you, Madam President, for the opportunity to contribute to this anti-gang bill 2021. Now, Madam President, I propose in my contribution to respond to the speakers that have gone before me, which is Senator Lochmedial and to some extent Senator Richards, but also to indicate in as wholesome a nature as possible what I think the merits of this bill is and where I think this bill is turning out to be most effective. So let me begin by, in some way, responding to Senator Richards, who in his contribution indicated that the definitions in relation to gang, gang leader, and gang member, as well as gang-related activity, would have needed to be updated somewhat because of the way gangs are evolving. Now, before I respond specifically to that, let me just say this. I've come to understand that when doing things like this, utilizing the correct label goes a very long way in terms of helping to find a solution. So to me, when I looked at the definitions of the four things I just called out, I understood right away that this was the crux of the bill. And by crux, I mean that if you didn't get these four right, well, then you would have problems with the bill in its entirety. Now, Senator Richards, I understood when you said that the way gangs are evolving now is that they're coming together for a short period of time to commit an act somewhat, and then they will disband and they may never come together again in that form. Now, when I read the definition of gang, for example, and I'll just read it out, means a combination of two or more persons, whether formally or informally organized, who engage in gang-related activity. Now, to me, that's very, very broad, and it needs to be broad because you did admit that one of the most difficult things when dealing with anti-gang legislation is, one, determining what a gang really is and sort of executing by way of preventing gangs from forming. But to me, that definition is extremely broad, and you would want it to be broad in that manner because you want to capture as wide as possible different incarnations of what people coming together to engage in nefarious activity would represent. To me, when I thought of a gang, I thought of it in two types. That is organized and disorganized. The organized gang, you will see some sort of a branding taking place with them, and Senator Richards would have called out the name of one of the gangs. Anybody can get it. That's a type of branding in that relation to gangs. But the second type, which is the disorganized kind, is the one that captures what Senator Richards was saying. The ones that may come together to commit the nefarious activity and then they will disband. And you want to be able to capture that because what you're trying to prevent, Senator Richards, is the nefarious activity. You see, the problem is when you start to say two people come together to do something, you can capture all kinds of groups in Trinidad and Tobago. But it is that nefarious activity that you're trying to prevent that becomes very, very important in this definition. And in that, you go on to describe what a gang leader is based on that, and then a gang member, and then you outline what that gang-related activity is. So it is not so much that the gangs are involving that they come together to commit one activity. It doesn't matter. It doesn't matter if they come together to commit one activity in 1 year or 1 year at a time. Label them as a gang. Because when you start to investigate that activity and you capture those individuals per se, then you can charge them under this piece of legislation. Because you came together to form a gang, no matter how long the gang lasted, to commit that activity, which is what you're really trying to prevent. So, Senator Richards, in relation to the gangs evolving to do that, I think this bill still captures them in this particular definition so that it could have that kind of effect. Madam President, let me move on to some of the comments made by Senator Lochmidial, and I'll go through them one by one as I have them here. Now, Senator Lochmidial, early in her contribution, in response to the statistics that the Attorney General gave in relation to the number of gangs being reduced in Trinidad and Tobago, asked the question in terms of questioning the statistics as to where did the gang members go. Now, I listened to that question, and I didn't really understand what the member was trying to get at, because to me that's the point. You don't have a gang members association. You don't have a gang members regulatory body. The fact is that you want to prevent gangs from forming in the first place. So if the police commissioner is indicating that under the previous anti-gang legislation, that you've had a reduction in gangs of over 30% and a reduction of gang members of over 58%, then to me there is some effect taking place there. The gang members that decide not to collude with each other or to enter an organized gang, they don't need to tell anybody. They just need to stop. So you don't need to ask the question, where did the gang members go? What we need to know is that they're no longer engaging in gang activity, and that is what the police commissioner was speaking to. Madam President, Senator Lochmidial went on to speak to the government capitalizing on emotions running high when the Attorney General speaks to the incidents that occurred in December and January, and saying that under the definitions that we have here, you could say that it's a gang engaging in this activity. I don't think it's the government capitalizing on emotions running high. Emotions are high all throughout the country. Everybody wants a solution to this problem. And if to drive this point home, Madam President, just today, the Guardian newspaper is reporting another incident in relation to a PH taxi driver and a female passenger. It's not about capitalizing on emotion. It's about solving a problem. What do you expect the Attorney General to do? He's going to bring legislation that seeks to treat with a problem that the entire nation wants solved to the benefit of every single person. So it's not capitalizing on emotion, Madam President. It is just trying to solve a problem, beginning with legislation and execution of that legislation. Senator Lochmidial went on to say, as she always does when it comes to anti-gang legislation, that 291 people were arrested, and then asked how many have been charged. Now, I understand where Senator Lochmidial is coming from in terms of asking that question, and she's looking at it from the standpoint of detection. But she's also indicating that because you have arrests taking place and because you're not getting conviction, and that is reason for why the law is not working. Well, that's not the case, because the law has two effects that I've seen thus far. One is deterrence, and the other is detection, to which Senator Lochmidial is referring to. But for me, like I indicated at the start of my contribution, if you're going to label something, label it properly. And in my mind, anti-gang legislation should be as important as the legislation that makes murder an offense. If it is that the detection rate in relation to murder drops to a certain point, 5%, let's say 2%, 1%, are you going to call for the removal of the Offences Against the People Act? Are you going to call for that? Is it that if people are arrested and let go because you didn't have the evidence or whatnot, are you going to call for the removal, or it's not working, so therefore we should cancel that or repeal that? No. This anti-gang legislation should be as important as that. And let me just respond in relation to those calling for a sunset clause. I don't fully agree to that. We have had this piece of legislation debated several times since I've been in this parliament. And each and every time, we're going back and forth with the opposition and the government. We reduce the sunset clause, we increase the sunset clause, and on November the 20th, it was removed, and the police commissioner had to argue, had to ask, and then had to beg for this to be brought back. And I understand why. Because if it is that he's seeing the deterrence effect of the legislation as it was before, then I see why he would be asking for that. So, Madam President, Senator Lachmidial went on to say that, and I took it this way, that the anti-gang law may not be needed because you could use existing law to solve the gang issue. I would say this. I don't think the senator understands exactly how gangs work. You have a gang leader. You have gang members separated into different titles, whether it be an executioner, whether it be a driver, whether it be whatever, a lookout. So you're telling me that if one gang member within the gang executes a murder, that under the existing law, we pick up that individual, and let's say you get the conviction and you charge that person. You know what happens in that gang, that institution? The gang leader brings somebody else in. There's a new executioner. Okay, let's say you find that person, charge them, convict them. You bring in a next person. It doesn't really solve the issue. And for me, when I'm looking at this anti-gang legislation, you know what I'm seeing? You pick up the gang member that committed the murder. You pick up the gang leader that did the instruction. You pick up the driver. You pick up the person that bought the gun. You pick up the person that collected the money. And to me, it's a more holistic approach in terms of treating with the issue of several different individuals who need to be in place to execute that particular crime in relation to the gang. That is the benefit. That is where you would do better than just using the existing law in a silo or in an individualistic manner. Because you can take down the entire gang entity doing that, with all the offenses that have been created in the bill. Madam President, let me just respond, because I'm hearing this argument all the time. What is it that the opposition wants? Tell this nation, we bring a special majority bill, you knock it down. You jump up to say that the opposition will not support any special majority bill that this government brings ever. So when the Attorney General, who's trying to do his job, brings a bill that is a simple majority, you then stand up on the podium and say, change it back to special majority. What's the point? Is it that you just want us to bring special majority bills so that you could turn it down? The nation is asking for a solution. We have asked from since 2015, when this government first came into place, to work together towards solving these problems. And at every step of the way, it's like pulling teeth. And just by the mere utterances today, special majority, simple majority. We bring one, you knock it down. We bring another, you knock it down. But we cannot sit down and wait for the opposition to find whatever reason they need to support the legislation. The work needs to be done to the benefit of the people of Trinidad and Tobago. So you can stop saying bring special majority bills and then knocking it down when we bring it. We will do the work as is required by us and as is mandated by the people of Trinidad and Tobago. Madam President, the last comment made by Senator Lachmidial was that no piece of legislation will resolve crime if the TTPS doesn't have the resources. Okay, I can understand that. That makes sense. But the biggest advocate for this bill is the person responsible for utilizing the resources given to them, which is the Commissioner of Police. From the time that the previous bill was not passed in the House of Representatives, the Commissioner of Police was the most vocal individual. And he did not say, we don't have any resources to implement that bill. He begged, He asked, he pleaded up to 3 weeks ago when he came before the Joint Select Committee of National Security. He indicated to us what they were trying to achieve and what they were doing and why the bill is so important. And the question I'm asking is, would he really be asking for this bill if he didn't have the resources to execute anything under the bill? That's not the case. That's a cop-out. That's a cop-out to say that they don't have the resources. The Commissioner of Police is fully capable of implementing this. That's why he's asking for it. He is seeing the results. And the best that we can do is give him what he's asking for so that he can execute what needs to be executed. Madam President, I want to respond to Senator Richards now, which is just one comment he was raising. And he raised the issue of people being indoctrinated into gangs in prison, especially the ones on remand. Now, I understand exactly what he is saying. And he indicated that it was about 60% of people entering remand end up being indoctrinated into gangs. And what I'm going to do, Senator Richards, in response to that, the next time we have the TTPS in front of the GSC, either one of us could do it, is find out exactly how many of those people stay in the gangs after their case is disposed of. Either the case starts or the case is disposed of in one way or the other. Because I could understand why that number is so high. You're going into a smaller population, and survival is key. So I want to suspect you're joining a gang probably to survive whilst you're on remand in prison. But the question I'd really want to ask, and we will get the answer, is are they joining the gang or remaining in the gang when you remove that survival or that necessity for survival once they're on remand? And I ask that in the context of the numbers that the police commissioner put out. He's seeing a reduction in the number of gangs and a reduction in the number of gang members. So in my mind, something is not adding up there. If it is that you have all of these people being indoctrinated behind prison walls, when they are coming out and they're entering the gangs or remaining in the gangs when they're coming out, what is the numbers there? Is that adding to the 1,114 gang members that exist in Trinidad and Tobago now? Or is it that really and truly they're just gang members in the prison and when they come out, they let go of that life? Or is it, as you indicated, Senator Richards, it's a factor of time? That if they're spending 10, 12, 14 years in remand, that they're really not adding to the number that's outside. Yeah.
Senator De Freitas, that the arms of the gangs stretch outside of prison walls. And if you're protected inside the prison walls, you have to continue doing the bidding of the gangs inside the prison walls to continue being safe. So the numbers may be adding to outside.
Okay.
It's not as simple as an exclusive zone inside the prison, and when they come out, they're free. Okay. But the gangs have tentacles outside the prison walls, as we all know.
Well, we will definitely, the next time the Commissioner of Police is in front of the Joint Select Committee, we'll definitely drill down into that more in relation to that. So, Madam President, I just want to move on to the bill that is before us. And in reading through the bill, let me just say this. There are three main areas that I think where this bill is properly effective. The first is in relation to Clause 5, which treats with the act of being in a gang, whether as a leader or a member, and creating that as an offense. So what you want to do, because a gang is an institution like any other, and you have to think of it and treat it like that. And so when you create the offense of being a gang member or a gang leader, you're effectively putting pressure on that institution that has been set up to engage in criminal activity. First, by ensuring that when it is you capture those individuals, you're removing those individuals specifically from that institution. So you're making it an offense. So there's a deterrence factor there, because you know if you're caught being a gang member or being a gang leader, well then an offense has been created and you can be captured and you can be convicted and sent to jail. So there's a deterrence, and then there's a detection factor, which is if you're already a gang member and you're engaging in that activity, then the same process applies and those individuals are removed there. But there's a second aspect that speaks more to deterrence and somewhat detection as well, but ever so slightly. And we've seen this time and time again, but we don't really speak about it. And that is the community in which the gang operates. We don't really talk about that. This bill speaks to it, especially in Clause 11 and Clause 12, as it relates to hiding or aiding and abetting gang members and gang leaders. To me, that's how some of these gangs survive. And I will explain a little later down when I'm wrapping up exactly where that connection comes from. It's almost like a Robin Hood type mentality that's occurring there. But within the community that the gang operates, you have a sort of protection taking place for one reason or the other. And that is what I thought was key in this bill. When you put forward legislation that makes it an offense to aid and abet or hide gang members and gang leaders, it means that they can no longer rely on their community for any kind of protection whatsoever. Especially if that community knows that you can be arrested and charged just for helping out gangs in that regard. And perhaps the biggest example of why that is important, what is the name that we give to gang leaders now? Anybody remembers? Community leaders. Why? Why? There's your connection right there. That's why this section of that bill, Clause 11 and Clause 12, is important. It breaks that connection. Because you don't understand how difficult it is for the TTPS to do their work if they have to enter a community that immediately is against them in protection of those engaging in activity that is detrimental to the community in the first place. We have to get rid of these labels. Stop calling them community leaders. Break that connection between the gang and the community. Madam President, the biggest effect that this piece of legislation has in relation to gangs comes by way of attacking the one thing that no institution on this planet could survive without, and that's human resource. And it does so in 4 ways. Gang members can leave, and this bill makes it an offense to prevent a gang member from wanting to leave. And I will drill down into that a little bit. That's at Clause 9. Gang members cannot be recruited. That's at Clause 6. The one that we never talk about, gang members die. You live by the gun, you die by the gun. That's the activity that they're engaging in. Gang members do die. We've seen it. Rival gangs fighting each other, they get shot, they die. And then you have, in relation to the finances, which is the forfeiture of property at Clause 17. So when Senator Lachmidiyal asked as to whether the statistics was true in relation to the move from 211 gangs to 129, there's a way to figure that out. In the Joint Select Committee of National Security, do you know what the Commissioner of Police told us? Gangs are now relying on 14, 15, and 16-year-olds. That's where they're recruiting. So if you're not inclined to believe the statistics, believe this, that if there's a reduction of 58% in bodies in relation to gangs, then that ties in with what we were told by the Commissioner of Police. They're not finding individuals to enter the gangs at the older ages anymore. So they're going down to the 14-year-olds, the 15-year-olds, and the 16-year-olds.
Senator De Freitas, you have 5 more minutes.
Thank you, Madam President.
And if there's someone, I think I heard a device go out, I would ask you to leave the chamber for 5 minutes.
So if they're going down there to intimidate and recruit those individuals, it tells me that they're having a problem with the human resource, which is exactly what you want. So as much as Senator Lachmidiyala is talking about conviction as the indicator as to whether the bill works, my better indicator is if gangs cannot even form. And if you can't get the human resource to enter the gangs to execute what it is you want to execute, then isn't that a better indicator? So, Madam President, in conclusion, let me just say this. The bill, in my mind, has had some effect in its prior incarnation. What we need to do is to give this bill the length and breadth of time to effectively work so that people in Trinidad and Tobago could breathe a sigh of relief in relation to what is taking place. And the final statement that I want to make, and this is to the population of Trinidad and Tobago, we need to stop calling these individuals who enter these gangs monsters and demons. Labeling them as monsters and demons does not deter them. I honestly believe that they're embellished, that it builds up their ego when we do that. Don't do that. Call them what they are, a cancer to society, to be treated with in the exact same way you would a cancer of the body. Surgically and specifically dealt with. That's how you treat with them. And that is what this bill hopes to do. Madam President, with those few words, I thank you.
Senator Mark.
Thank you, Madam President. Madam President, the bill that we are debating today, its short title is the Anti-Gang Bill of 2021. I would like to frame my contribution in the context of consultation, definitions, the whole question of police power and powers, the efficaciousness of the proposed measures that are outlined in this bill, given its past history. And I also want to add some further amendments to this piece of legislation. Madam President, I want to make it clear from the outset that we are committed as the alternative government to the promotion, to the formulation of what I call and what we call good law. We want good law for our country. As you know, this bill was introduced last Tuesday. And this Tuesday, a couple of days later, we are debating this bill. I would have liked to ask the Attorney General, who is not here, what element, what level of consultation did the Attorney General pursue in promoting this piece of legislation, having regard to the removal of its certificate, calling for a special majority? Did he consult with the Law Association? Did he get any comments from the Law Association? What about the Southern Assembly of Lawyers? What about the Police, Social, and Welfare Association? What about the Prisons Officers Association? Were these organizations reached out to? Were their views sought? These are questions I would like clarify, Madam President. So democratic participation in the formulation of legislation is absolutely essential, Madam President. What I also want to say from the very outset is that no one, including the Attorney General on the government bench, has dealt with the social measures, the preventative measures aimed at addressing the challenges faced by marginalized youths in our country that find themselves locked into this gang culture, in being recruited into this gang culture. Where is the investment to encourage these youths to live that kind of existence and way of life, Madam President? Madam President, remember in June of last year, there was an eruption of activity in the city, and a community recovery committee was established. Where's the work of that committee? What opportunities have been advanced by this committee to assist the youths? So, Madam President, when you look even at the newspapers today, not today, on Sunday rather, there were some very powerful articles written. There's one particular forensic psychologist, Aisha Prout, I think, doctor, and she said in this article on page 9 of the Sunday Express, helping criminals get out of the vicious cycle. Psychologists, yes, punish, but rehabilitate. And she went on to explain what she meant by that. And Madam President, I won't detain you on this matter. I would like to go to the item of enforcement, law enforcement in the legislation. If you go to the definition section in clause 3 of the bill, Madam President, and by the way, before I go into definitions, and this one in particular, may I remind this Honorable Senate that the Law Association has been consistent in its opposition and rejection of this anti-gang bill. They did it in 2016 when Reginald Amor was its president. They did it in 2018 when Douglas Mendes was the president. And I think there was another statement in 2020 opposing this particular piece of legislation that has artificially been adjusted, but to achieve the same objective. So I don't want it to be said it is only the United National Congress that has its reservations about this piece of legislation. The Law Association of this country is on record as opposing this piece of legislation, along with others, of course. Madam President, the Attorney General, in a very flippant manner, very light-hearted manner, while he was speaking, he told the Senate, I intend to make an amendment to the definition of law enforcement to include, Madam President, surreptitiously, the SRP or SRPs, municipal police, and I understand he said also the Police Complaints Authority. What is the business of SRP in this piece of legislation? I would need clarification from the Honorable Attorney General. And up to now, as we speak, I haven't had sight of the amendment that the Attorney General is proposing for this particular piece of legislation. Madam President, the Anti-Gang Act or bill gives to the police and gives the police officers significant power under Section 16 of the legislation. Madam President, powers are given to the police to arrest persons. They have them detained, this time not for 36 hours, but for 48 hours. And then to apply for further detention for 36 hours and through an ex parte injunction, 14 days. I want to say, Madam President, in looking at this piece of legislation, it cannot be viewed in isolation, particularly with what the Honorable Attorney General introduced while he was speaking. Whenever we have to look at legislation, and especially the one that is before us, which purports to vest power in the hands of the police, it is our responsibility as parliamentarians to look at that power and to look at it very closely and to see how this power has been used, and in some cases how that power is being abused in our country. Not all police officers are misusing or abusing their power, but there are police officers with this kind of legislative framework and the clauses contained therein can abuse and misuse their power unless we have the relevant and necessary checks and balances to ensure that they do not go outside of their remit. So, Madam President, if what I heard earlier in the Attorney General's contribution is true, that he intends to make an amendment to include special reserve police officers, I would like to ask the government, those powers that we have in Section 16 of this piece of legislation that is before us, Madam President, I think it's in part, let me get the exact, part 3, 15, 16, clauses 15 and 16, Madam President. I would like to ask the government today whether these powers will also be exercised by the SRP, who the Attorney General is saying he wants to be part and to be included under law enforcement. I ask this question because we are concerned with the way in which the government has been using and abusing the SRP mechanisms in this country. And I hope that the Attorney General will be able to provide us with answers on this matter. No, when you're winding up, not now. No, not now. Not my time, not my time. My time is limited. Madam President, I would like to make it very clear. And when we look at this bill is already given tremendous power to police, to the police to conduct investigations. And therefore it is important to consider whether the SRPs would also be enjoying this same power. For instance, Madam President, I have a copy of the SRP Act, and I want to tell this Honorable Senate the concerns that we have on this side with this proposal that the Attorney General has floated. I have been advised, and the Attorney General, when he's winding up, can tell this country what is the strength of the Special Reserve Police today. My understanding is that it is 8,000 strong and growing. 8,500 strong and growing. They are more, as I understand it, than the sanctioned strengths of the Trinidad and Tobago Police Service. But the only danger of this is that when you look at the Special Reserve Police Act, Madam President, you will see how these SRPs are appointed, who the Attorney General is indicating he wants included under the law enforcement. Madam President, there is a fundamental distinction between recruitment, training, and the qualifications for SRPs and police officers. I have the evidence right here before me. I know what they are entitled to, Madam President. So when the Attorney General says he wants to incorporate the SRPs into this exercise, then we have to be very, very suspicious about it, Madam President. Madam President, I would ask the Attorney General to desist from making any amendments that would include the SRP in this piece of legislation. The SRP is under the control of the Minister of National Security. And we cannot allow a private police army to be developed in this country under the direct control of the Minister of National Security. Madam President, let me bring to your attention clause section 6 of the Special Reserve Police Act to tell you the danger, the fire that we are playing with here. Madam President, section 6 of the SRP Act says, subject to the general order and directions of the minister, the commissioner shall have the general command and superintendence of the Special Reserve Police, and he shall, that is the Commissioner of Police, be responsible to the Minister of National Security for their efficient condition and for the proper carrying out of this act. How can a police commissioner that is independent under the Constitution in terms of his activities, Madam President, may I invite you to look at section 123A of the Constitution. And I want to tell you, Madam President, 123A is an entrenched provision under section 54 of our Constitution. The framers of the Constitution wanted to ensure that the police commissioner has supreme independence and is not subject to the general control and directions of a politician. And this is what is taking place with this provision that the Attorney General has threatened to introduce as an amendment to this piece of legislation. Well, whatever you said, you will correct yourself at the end of the day. Don't intervene when I'm speaking. All right, Madam President, may I continue, please?
Please continue to address me.
Yes, Madam President. Thank you. Madam President, may I indicate that it is wrong. Madam President, I have been advised that hairdressers, volleyball players, footballers, cricketers, I have been advised that a QC out of England called Edward Jenkins is a SRP. Could you imagine a Queen's Counsel is a special reserve police officer in Trinidad and Tobago? And Madam President, I have been also advised that there are firms out of the United Kingdom whose members are all SRPs with the same powers as a regular police officer. But Madam President, the only difference here is that the Minister of National Security has a big role to play in that exercise of recruitment. So the police commissioner confirms or approves, but the Minister of National Security has a big role to play in recommending. So the Minister of National Security is literally in charge of a coercive arm of the state. This is the scene that can lead to a mongoose gang being established in our country, Madam President. And we want to make it very clear to the Honorable Attorney General, do not seek to bring a mongoose gang into this piece of legislation. And Madam President, I believe the time has come for us to amend this act to make it consistent with our Constitution. Our Constitution under 123A says the police commissioner is an independent office holder. And if you're going to attack that office, you need 2/3 majority. You need 2/3 because it falls under Section 54 of our Constitution. Madam President, it's friends and family, I understand, who are in the SRP in this country.
Mark, we're dealing with the anti-gang bill. You've made a point in answer to something that you said the Attorney General raised in his opening statements. And I will ask you now, though, you've spoken at length about SRPs. You need to treat with other aspects of the bill.
Yes. Madam President, there are so many other aspects of the bill, but with your leave, I shall come back to that matter. But let me go on as you have advised. Madam President, I want to indicate that legislation, for it to be effective and efficacious as it relates to results and outcomes, must be scientifically grounded and it must be data-driven. You cannot come here, Madam President, and indicate to this country that you are introducing legislation to bring about changes, but the legislation that you are proposing has not delivered anything effectively as it relates to convictions of the so-called gangs that we are talking about. Madam President, I have in my possession data, which I will share with this Honorable House. Data from 2005 to 2020. And it deals with 30 offenses falling under the Anti-Gang Act in this country. And the data reveals, Madam President, between the period 2009 to 2020, the total number of gang members been arrested for firearm? One, Madam President. Assisting a gang member in terms of ammunition for the period 2000 to 2020, Madam President, 0. That's the data I have. Let the Attorney General dispute my data. He came with just overall figures, Madam President, indicating that the number of gangs has been reduced from 400 to 100. And the number of gang members has been reduced from 4,000 to 1,000. That is not what we want alone. Come better. Tell us how this anti-gang law has been working since 2011 when it came into being. Madam President, assisting a gang, 2 persons arrested. Not even charged, Madam President. Not even convicted, 2 persons between 2011 right down to 2020. Madam President, being a gang leader, 11 persons have been arrested for being a gang leader between 2010 to 2020. Madam President, being a member of a gang, how many people have been arrested? You brought legislation here today saying that you want support because this will fight crime and criminality. But the statistics and the data and the scientific facts do not square up with your reality. This is all a PR stunt, Madam President. This is simply legislation by fright, legislation by fear. That is what this thing is about. And trying to mama-guide the population. Charges in relation to the Anti-Gang Act, Madam President, 10. Being a member of a gang, 240. Madam President, those are people who have been arrested. The state of emergency alone that they condemned, Madam President, had 211 of them, Madam President, being arrested and later on being freed because the DPP said he was not pursuing that matter any longer, and some of them have been compensated. So, Madam President, from 2010-11 right down to 2020 September, which is the date of this piece of data I have here, 240 minus 211, 208 from that, Madam President. And you will tell me what you get. That is what the Attorney General wants us to support today. We have no problem. We say, Madam President, if you want to bring legislation, we want legislation to work. We don't want legislation to just be on the statute book gathering dust and you're not having any effect. To coerce a person to be a gang member between 2010 to 2020, 1 person has been arrested. 1 person. But you come to this parliament giving the impression that this thing is working. The data does not support your narrative. Counseling, Madam President, a gang. 2009 to 2020, 1 arrest. 1 arrest. Madam President, gang leader and members benefiting from being a gang leader, 5 persons have been arrested between the period 2010 to 2020. And I have it right here. Gang members on lawful shooting. How many have been arrested? 1. 1, Madam President. inviting persons to support a gang. How many persons have been arrested? 1 between 2010 to 2020. Knowingly assisted a gang member in the commission of a gang-related activity. Madam, how many people have been arrested? 0, zilch, nada, nothing. Madam President, we go further. Knowingly providing support to a gang. How many people have been arrested? 0, zilch. Madam President, here is one. Possession of ammunition for the benefit of a gang. How many have been arrested? 0. And we swimming in guns in this country in terms of gangs. And for 10 years, not one person has been arrested, Madam President. Providing instructions to a gang leader. How many have been arrested? 1. Providing support to a gang leader. How many have been arrested? 4. Retaliatory action. Madam President, if you're a gang member and you leave and I come for you, how many persons have been arrested? 0. That is what the data is showing, Madam President. And how many people have been arrested for supporting a gang over that 10-year period? 2. How many have been arrested for supporting a gang leader? 2, Madam President. Madam President, I have so many others that I won't detain you. But the point I'm making is that this Attorney General and this intellectually bankrupt and visionless, directionless PNM government has done nothing effectively to deal with crime in this country. It's only artificiality, superficiality, and old talk. And when we try to provide answers and assistance, they don't want it at times. They don't want it, Madam President. So we are not convinced that the government is serious about this matter, Madam President. So let's go back to the bill, Madam President, after I have given you that excursion into reality. Let's go back to the bill. You come with a piece of legislation that is the government, The burden of proof. I thought we are living in a republic called Trinidad and Tobago. And I thought under Section 5, 1F of our Constitution, there's a provision that says an individual, a citizen of this country, is innocent until proven guilty. Well, the Attorney General, in this piece of legislation, has shifted the burden of proof, Madam President. It is in Clause 10, and it is in many other clauses in the bill. They say, you guilty, prove your innocence. You are guilty, Madam President, you prove your innocence. That is France. That is the law of France. That is their jurisprudential principle. That in France, you are guilty, you prove your innocence. In Trinidad and Tobago, I want to remind the Attorney General, under Section 5, 1F of our Constitution, citizens are innocent until proven guilty. And if you want to reverse that burden, you bring a special constitutional majority because it is entrenched in the Constitution. So, Madam President, that is an area we like to have established very clearly. Madam President, when you go to Clause 16 of this bill, Madam President, I don't believe that the framers of our Constitution ever anticipated that one day in our life we will have a government in power manipulating our Constitution, assaulting our Constitution, assaulting our democracy,
Senator
as this government is doing.
Senator Mark, your language has become increasingly inflammatory, and I'll ask you to dial it back a little bit.
Madam President, I go to clause 16 and I go to subsection 3. Madam President, you are detained at the pleasure of the police for 48 hours, according to the law. Liberty is something that you cannot treat lightly in a democratic society. You cannot deprive an individual of his or her liberty easily, Madam President. But you want to do it in this legislation, but you don't want to put in the requisite constitutional majority to take away the people's liberty, Madam President. So you can be detained for 48 hours. And when you're detained, Madam President, it says in subsection 16, subsection 3, and I quote, where a person is detained under subsection 1, that is for 48 hours, the police officer, no rank, so it could be an ordinary policeman detaining you, a constable. And the SRP, Madam President, as you know, they don't have any tenure of security. They are contract workers. It reminds me of, Madam President, before slavery was abolished, you had people contracted as apprentices. And that is what's going on with the SRP. My heart bleeds for the SRP. The advantage that this government has been taking over those SRP officers. Madam President, I know you have told me I have spoken enough on this matter, but I want to indicate here, I want to call on the Attorney General to pay the SRP, the constables, their back pay. Pay them. I go on to this section here, Madam President.
Senator Mark, you have 5 more minutes.
Yes. Madam President, I want to make an amendment. I'm proposing an amendment to 16, clause 16, and I'm adding after A and B the following. Provide the person or his attorney at law with the custody of his or her station diary record. I want to have that included in this provision. That is clause 16.1, clause 16, subsection 3. I am adding a new C, Madam President. Madam President, I would also like to propose the following. Under Part 5, Clause 6 of the legislation, the minister with responsibility for national security may by order, subject to negative resolution of Parliament, amend the second schedule. This bill is saying with a simple majority that the Minister of National Security, who is interfering in SRP police business under Section 6 and 7 of the SRP Act, which is unlawful, unconstitutional, and illegal. That individual, whoever he may be, is now given the power under this draconian and dangerous, concerning, and disturbing piece of legislation in this section, the power to make resolutions subject to negative. To amend what, Madam President? The second schedule. Madam President, I invite you to look at the second schedule. It's about application for detention order. So the minister is being given the power to adjust detention orders whimsically, and we have to be rushing for legal notice to see if we can come and annul it. No. We want an affirmative resolution. We want it to come here and be debated. That is what we are proposing, Madam President. Madam President, I saw the government introduce offenses 47 and 48. You know, I'm always concerned about this government and what their intentions are, particularly when you could recruit a senior counsel called a QC, Edward Jenkins, as a SRP in our police service to look after white-collar criminals in this country after spending $66 million of taxpayers' dollars for a firm that he's attached to.
Senator Mark,
Madam President.
I'm not sure where you are going with this. In fact, I'm sure it is away from the bill that is before us. I will ask you in your last few minutes to wrap up, make your point.
Madam President, I thank you very much. Madam President, I invite you rather to go to 47 under offenses, conspiracy to defraud the state. I would like, Madam President, for the Attorney General to tell this Parliament and this Senate whether that is retroactive or whether that is prospective. Because my understanding, and the attorneys are here, they can advise me. Madam President, you're an attorney, you can advise me as well. When we talk about conspiracy, are we talking back in times, or are we talking prospective, or are we talking both? And this is a dangerous profession here. And if you're going to deal with people's liberty under this section, this is another excursion into adventurism by this administration. And we would like, Madam President, to ensure that the liberties of the people under our watch, the alternative government of Trinidad and Tobago, the United National Congress, under our watch, we will not allow the PNM and its Attorney General to come here and use SRP, use municipal police, in order to trample upon the rights of the people, knowing very well, Madam President, that under Section 6 and 5 of the SRP Act, the Minister of National Security gives directions and control over, he has directions and control over our police commissioner. I defend our police commissioner today. I stand by his side and I ask
Senator
the Parliament
your time is
to
up.
thank you very much, man, to stand by his side. Thank you.
Senator Vero.
Thank you, Madam President. Let me start off by declaring how much I enjoy listening to Senator Lutch-Medial. I always appreciate her insights and her recommendations. I think she's a tremendous asset to this Senate. As I was listening to her, I thought, what would be really ideal on legislation as important as this was to have this special majority suggested by Senator Lutch-Medial, but an opportunity here for greater collaboration between the opposition and the government to really flesh out, take those recommendations to heart, and come up with really great legislation on something as important as this, you know? And then for the opposition to really support this bill if they could negotiate those amendments. That, to my mind, would be far more productive than looking to challenge the constitutionality of the legislation after the fact. The Attorney General has said he's come here to listen, so perhaps the opposition can sound him out. This bill has had me on an intellectual seesaw. Initially, I was against it. But now, I find that my view has changed. In discussing this legislation with different people, I kind of discerned two competing narratives. One narrative is that the executive and the police service, an independent organization established under the Police Service Act, have hatched this plot to turn Trinidad and Tobago into a police state. And this bill is all part of an overarching framework by an out-of-touch government to dismantle constitutional rights so that citizens are made subservient and they're kept in their place by political overlords who serve a greedy oligarchy. That's one narrative. And the second narrative, of course, is, hey, gangs are exceptionally dangerous and well-armed entities who pose a real and present danger to law-abiding citizens and to the peace, stability, and good order of the state. So the purpose of this debate really is to cut through the fog of confusion and to choose the option which best serves the public interest. Both narratives require us to consider whether, on the one hand, the proposed anti-gang laws violate the Constitution, in particular, entrenched fundamental rights like freedom of assembly, freedom of movement, the unlawful detention of persons, and the rights of the individual. And whether, on the other hand, this is a legitimate, reasonable, and proportionate attempt on the part of government to protect and keep safe our citizens, our homes, our businesses. Now, I agree with Senator Lutch-Medial that the safer course is to go for the special majority. But what happens if we don't get that support? Do we abandon this legislation? This is heavy stuff, and the buck stops here. It stops here with us. Government has carried the baton as far as they can. Whether that baton is dropped or whether that baton gets to carry across the finish line, that's on us. That's the burden we carry today. That is a responsibility we signed up for. So, what are the arguments against the bill? When I first saw the bill, my initial reaction was one of cynicism. I was then, and I am still concerned, about the number of unsolved crimes, the low crime detection rate, police corruption, bad apples in the police force, and the burning issue of excessive police force and extrajudicial killings. I'm also concerned about the social aspects and whether this legislation can change the underlying dynamics of gang activity in the country. Where joining a gang may be a very natural process for many youth, especially in economically deprived areas. If you feel alone and vulnerable, you have to gang up for survival. Your gang then becomes your family, and we have to deal with the risk factors where some have a greater chance at joining a gang. I'm aware of studies showing the negative effects of social and economic inequality. how inequality breeds resentment and highlights dissatisfaction, how inequality divides us into different camps and erodes our trust in one another, and how inequality changes the way we think, the way we act, encouraging risky and self-destructive behavior. We have many communities in Trinidad where people suffer from both poverty and inequality. In the past, I've spoken about the need for a multifaceted approach and about the state not being a one-note Johnny where the heavy hand of the law is the preferred or the only tool available to law enforcement. The country needs a wide range of policies if the problems associated with gangs are to be resolved. We need a master plan to effectively deal with crime, ways to improve the economic status of depressed urban areas, ways to improve the education system, and ways to tackle antisocial behavior, making gangs less attractive. So, if this legislation is out of sync with what is happening on the ground, it may well do more harm than good. A balance of prevention, intervention, and suppression strategies are important for success. Otherwise, as Senator Mark has suggested, this bill may be little more than a cynical ploy designed to create a tough-on-crime appearance. So by itself, this bill is not a panacea. If we're going to solve the gang problem, it must be part of a master plan, making Trinidad and Tobago more equitable for all citizens. But that is a long-term, never-ceasing goal. Poverty and social inequality, should not, however, should not be used as a smokescreen for gangs to hide behind. Now, as to whether this legislation violates the Constitution, it may be instructive to note that jurisdictions like the United States, which are highly litigious, fiercely protective of their First Amendment constitutional rights, such as the freedom of association, they have allowed anti-gang legislation. The United States Supreme Court has made clear that no group of persons has the right to associate for wholly illegal aims. That court has held that anti-gang legislation is constitutional because it serves significant and often compelling government interests by reducing the threat to public health and safety caused by gang activities. I agree. No constitutional right is absolute. I agree that there is a duty on the state to protect fundamental rights and freedoms, and that where gang activity presents a danger to public order and safety, a danger to economic stability, and has the potential to inflict social damage, there is a duty on the state to protect citizens. When gangs become so strong that normal law enforcement techniques do not work, the claim about protecting individual rights rings hollow, especially where gangs have taken over communities through violence and intimidation, and yet are able to evade law enforcement because of clumsy, archaic, and convoluted laws dealing with accessories and abettors, parties to an offense, the law of criminal complicity. Closer to home, Jamaica passed anti-gang legislation in 2014. Ireland dealt with gang offenses under its Criminal Justice Amendment Act in 2009. In 2010, Australia passed some of the toughest laws outlawing organized crime, and in particular, motorcycle gangs. Even peaceful, sedate, stable Canada has introduced legislation aimed at combating the rise in gang violence. So this is not Trinidad and Tobago going off on some lark of its own. Now, you can ask, but is this overkill? Are we overreacting to this situation? Maybe it's not as bad as has been suggested. Is this bill disproportionate? When we go downstairs and we see heavily armed paramilitary police protecting us here in this parliament, is that a case of overkill? Can we honestly say that the deployment of those officers is just for show? And we can safely go back to the days of officers just carrying a baton? I don't think so. I agree with Senator Richards. We would do well to remember that it was an armed gang who stormed Parliament in 1990, killing and wounding innocent civilians. And again, how many gangs are we talking about? 2? 3? Between 10 and 20? Hazard a guess. According to my research, using statistics from the Crime and Problem Analysis branch of the Trinidad and Tobago Police Service, from papers put out by the University of the West Indies, and from reports of international organizations, we are talking about approximately 179 gangs. Now, 50 gangs would have been frightening enough. Well over 100, that's cause for serious concern. And we're not talking about book clubs and friendly associations. This legislation is not targeted at kids liming on the block, but at thugs and outlaws who pose a danger to communities and the wider society. Under this legislation, you are regarded as being in a gang when you engage in organized criminal enterprises and gang-related activity. Gang-related activity is listed in the first schedule and is directed towards activities such as drug trafficking, kidnapping, gun use, prostitution. Think about gang culture. Gang culture requires absolute loyalty. Loyalty to the gang above all others, including family, friends, the community, and the state. From the gang member's point of view, if you're not a gang member, you are nobody. You don't matter. And because gang activity is closely related to expanding income from criminal markets, and we heard the Attorney General talking about the white-collar crime aspects, gangs are always bidding for territorial expansion. And the desire to expand means that gangs are in a constant state of war with each other. Gang wars turn communities into battlegrounds where bullets fly indiscriminately, killing innocent bystanders. According to the United States Embassy's Regional Security Office report on Trinidad and Tobago for 2020, Port of Spain is seen as a critical threat location for crime. In particular, violent crime stemming from gang and drug-related activities which continue to drive the murder rate. At a UE conference not so long ago, it was reported that over the past decade, one of the challenges facing the small, divided society of Trinidad and Tobago is the intrusion of gangs in the sphere of money laundering and drug trafficking. And it was noted that the violence and intimidation that reigns in certain urban areas are hampering the development of community organizations and ultimately the ability of the population to improve their living conditions and social advancement. According to a report put out by the Council on Hemispheric Affairs, gangs are the new law in Trinidad and Tobago. In drawing attention to the country's rampant gang problem, reference was made to beheadings as a warning from gang members and the significant brutality of gang activity in Port of Spain. And disturbingly, that report suggests that gang activity in Caribbean nations has largely been ignored, despite the fact that in Jamaica and Trinidad and Tobago, gangs have become so ubiquitous that they represent a challenge to state sovereignty. According to statistics from the police service, gangs are responsible for the murders of at least 2,100 people, as well as numerous woundings, shootings, robberies, and other violent crime. More than 4,600 gang-related guns have been seized since 2010. So that is the stark and frightening reality facing us. Gangs promote violence and crime. They terrorize communities. They intimidate and kill witnesses. They are brutal. And those who play down the statistics or who try to sugarcoat the situation may be dangerously out of touch with the country's gang culture and how gangs are terrorizing citizens. So I am satisfied that this anti-gang bill is necessary law and its provisions have been carefully considered and constructed. I agree with Senator Lutch-Medial, we may need to do some tweaking at the committee stage, but the Attorney General has already indicated he's leaning in that direction. So I look forward to his proposed amendments in relation to clauses 5, 15.3, and 16. Senator Lutch-Medial's observations on extending a suspect's detention via ex parte application, very worthy of consideration. I think we must always seek to design provisions which are fair to both parties, fair to the suspect as well. But in general, I find that the mens rea requirement in the offense sections, knowingly or could reasonably have known, and the imposition of specific intent requirement ensures that only members who are aware of the gang's criminal activities or who actively participate in these enterprises are punished. Now, I've heard a lot of flack about clause 10.2 and that somehow we have reversed the burden of proof. I disagree with the interpretations that have been given there. 10 clause 2, to my mind, is quite clear. It follows 10.1. 10.1 says, listen, if you have been using a bulletproof vest or a prohibited weapon, if you have in your possession a bulletproof vest or a prohibited weapon, in the commission of gang-related activity, you have committed an offense. So what you're doing with a bulletproof vest, what you're doing with a gun, what you're doing with gang-related activity, the presumption is if you're caught in that situation, yes, you're in a gang, you're doing gang stuff. But what 10.2 says is, look, it's a defense if you could prove that you really did not know. So it's not a situation of just clumsily reversing the burden of proof. It makes perfect sense to me. I have no problems with that clause. In the United States, their Supreme Court held in the United States versus Choate that the practice of associating with compatriots in crime is not a protected freedom of association right. And I believe that our courts will also be reluctant to recognize gang membership as an activity protected by the Constitution. Senator Mark spoke about police power and the possibility of abuse. Does this legislation translate into a blight for the police? Of course not. Anyone who suggests that is being disingenuous because there are checks and balances in place. Within the police service, there's an internal affairs division that investigates incidents, suspicions of law breaking, professional misconduct attributed to police officers on the force. We have the Police Complaints Authority, an independent body mandated to investigate complaints against police officers involved in criminal offenses, police corruption, serious police misconduct. And then, of course, we have the courts, which will carefully investigate claims brought against the police for unlawful detention, breaches of constitutional and civil rights, unfair prosecutions. We have a cadre of judges who stand ready, willing, and able to act as guardians of law. So we must have confidence in the legal system and the ability of our judges to determine where the balance lies between the interests of the community and the interests of litigants. So given all these checks and balances, I do not accept that this bill is going to somehow turn Trinidad and Tobago into an undemocratic country or anything resembling a police state. And more to the point, at this very moment, petitions are being signed across the breadth and width of Trinidad and Tobago by citizens calling for a safer Trinidad and Tobago. We cannot be tone deaf to their pleas. So while I accept that this legislation cannot by and of itself provide a solution to the problem of gangs, and that unless we improve the economic and social conditions in high-risk areas, it will not change the underlying dynamics of gang activity in those areas, nonetheless, I genuinely believe that this bill is a much-needed tool to fight what is a serious crime issue and dangerous criminal organizations. And we must recognize that the police service are not just guardians who blindly protect and serve. The police service is a specialized agency with their own intelligence, their own legal and technical expertise. Besides the fact that it is the police who put their lives on the line when they confront well-armed and ruthless criminals, we should have due respect and regard for their expertise, their experience, their information when making recommendations on bills of this nature. So before concluding, I would remind the armchair philosophers and those who glibly declare that no rights can ever be touched, and those who refuse to accept that there are times when the national interests and the interests of the public are more important than individual rights, by retelling Aesop's fable about the wolves, dogs, and sheep. And this is how it was put over 1,000 years ago. There was a flock of sheep who were protected by a number of guard dogs. The wolves sent messages to the sheep protesting the discrimination which was being levied against them. The wolves said, "We only want peace, but we are being maligned by these dogs and their human masters," when in fact, it is the dogs who are dangerous. It is the dogs who are the slaves of people, and it is the dogs who want to enslave, control, and use you sheep. The wolves offered to swear a sacred oath of everlasting peace if the sheep would only get rid of these controlling and divisive dogs. The sheep believed the wolves, and they sent the dogs packing. But no sooner had the dogs departed that the wolves fell on the sheep, slaughtering them. Unfortunately, the sheep didn't realize what was happening until it was too late. Gangs are wolves in every sense of the word. And when we ignore or minimize the dangers associated with them, when we demonize and disempower those who would protect and serve us, we do our citizens and we do law enforcement a grave disservice. If we abandon communities and citizens to the inevitable destructive consequences of gangs, we should not be surprised at the result. And if slaughter ensues because we fail to pass this bill, then we are complicit. Madam President, I thank you.
Minister in the Office of the Attorney General and Legal Affairs.
Madam President, I thank you sincerely for the opportunity to contribute towards this bill this afternoon. Madam President, the bill before us today is necessary in a contemporary and a modern society. It is absolutely necessary in a world such as ours, where young people, Madam President, and children are amongst our most vulnerable. Madam President and my brothers and sisters of this Senate, I do respectfully say that this anti-gang bill, it is not a if, it is not a but, it is not a maybe, it is a must if we are to put a handle on criminal activity, especially criminal activity that affects children in this country. Madam President, I use the word vulnerable with certitude. As in my previous incarnation as a defense counsel, and I will share a very personal story with Trinidad and Tobago and this Honorable Senate. In my previous incarnation as a defense counsel, I recall, Madam President, appearing in my first criminal matter, a fresh-faced attorney at law, eager to learn. I distinctly recall going to the prison to meet my very first criminal client, a 14-year-old boy. Madam President, the scariest thing is to look into someone's eyes and see absolutely nothing. The scariest thing is to look into a child's eyes and see almost a soulless being. This young man, I will never forget. He said to me the best he ever felt was when a gun was placed in his waist. He said to me, and I will never forget, he said, the best feeling, and I'll put it exactly as he said. He say, I'll tell you. He said, the best feeling is walking down that square and knowing, boy, I could wipe out a man. I felt like a god. And this story remained with me because it was a 14-year-old boy saying to me that this is what empowered him. Now, this young man, Madam President, he was a part of a renowned gang at that time. And yes, I did secure an acquittal for him, and I applauded myself as a young defense counsel at that time. But now, in retrospect, I ask myself, did I really save that child? Yes, I secured him an acquittal, but did I really save him? Madam President, honestly, in retrospect, I don't believe I did, because what I did is I released him, as Senator Vieira said, I released him to the wolves that were still existing outside there in our society. The wolves that were waiting with bated breath to bring him back into gang culture. Madam President, I did not have a full opportunity then to truly save young men like this 14-year-old client of mine. But now, serving in the capacity in which I do as a minister of government in this parliament, I believe I now truly have an opportunity to save those young men who cannot save themselves. And this anti-gang bill, I truly and completely believe it's one way in which we can save our young men, especially young men from shattered communities in our country. Madam President, we must save them. With this legislation, we can save them. There are provisions in this bill to save them. This is our legislative intervention in an attempt to put a handle and suppress crime and criminal activity in this country. You know, I've heard many talks about the stats not looking good. But I want Trinidad and Tobago to ask themselves, I want our citizens to ask ourselves, what are we to do then? Simply sit by and do nothing because the stats don't look good on paper? We can't. As a government, it's our responsibility, Madam President. It is our responsibility to use legislation as the current one to at least for the very least to suppress criminal activity in this country. Now, there are many points that Senator Mark would have made, but I would leave this, I would address those comments in my winding up, because there are certain areas of the law that I want to address and put into the public record as it relates to this particular bill. If I may respectfully, Madam President, take my colleagues to clause 15 of the bill that appears before us, I will pay specific attention, Madam President, to clause 15.1 and 15.2 of the bill. Now, clause 15, Madam President, in essence, it deals with police powers of entry, search, and seizure. And 15.1 specifically states that a police officer may arrest without a warrant a person whom he has reasonable cause to believe is a gang leader, a gang member, or who he has reasonable cause to believe has committed an offense under this act. Now, why I've personally plucked out this particular clause is because I want to deal with the issue of reasonable cause. Because for some reason, there seems to be people in the public who believes that we are giving the police unlimited powers and there's no control. So to answer your question, Senator Vieira, you made a point, Senator Vieira, and I'm starting with this clause because you are correct. There are checks and balances on the police. And even within this legislation, there are checks and balances. And that check and balance, one of those checks and balances is found in the legal term coined reasonable cause. Now, I want the record to reflect, Madam President, that police officers cannot just arrest a man or arrest someone on a VAPS. They can't wake up one morning and just decide I'm going to take down a man because he's a gangster or a gang member. We understand as legislators on this side that the area of contention is that people, as I said before, may believe, or the public may believe, we are giving the police extended powers. But if I may respectfully address the case or allude to the case, Madam President, of Nigel Lashley versus the Attorney General of Trinidad and Tobago. Now, this was a particular case adjudicated upon by Justice of Appeal, Judge Justice Narain. And in this particular case, Madam President, Justice Narain dealt with the issue of reasonable cause and its meaning within the confines of the law. And he stated he was in full support of the principle of reasonable cause. Now, in that very same case of Nigel Lashley, Justice Narain also made mention to another case known as Dallison and Caffrey. Now, Dallison and Caffrey was a case which was adjudicated upon by Lord Diplock. And Lord Diplock, in that particular judgment, he said that the test for reasonable and probable cause has a subjective as well as an objective element. He went on to say that the arresting officer must have the honest belief or suspicion that the suspect had committed an offense, and this belief or suspicion must be based on the existence of objective circumstances which can reasonably justify the belief of suspicion. This, in essence, Madam President, is not an officer operating on a VAPS. It is not an officer operating on a whim. It is not an officer operating on a fancy. So by us inserting the clause reasonable cause, even though we are widening the hub and scope of the powers of the police, it must be done within the confines of reasonable cause. Now, Madam President, if I may even take us to our jurisdiction, a police officer need not have evidence amounting to a prima facie case, but at the same time, he must not act on a mere gut feeling. And that was actually taken from the case of Rup Narain versus the Attorney General, which is a local case. Now, the High Court, Madam President, in this particular case of Rup Narain, went into broad detail as to what was suitable to determine the arresting officer had a reasonable and probable cause to arrest someone. Now, in determining the issue in this particular case, the court took into account factors such as the nature, sources, and quality of information. The court illustrated the degree to which police officers had to be cautious in treating information before them. So by quoting these case laws and by defining and explaining what reasonable cause is, Madam President, what I'm saying is that, and by importing the term reasonable cause in this particular piece of legislation, what I'm saying is we are not legislating insanity by giving the police wide discretion in arresting. The police officers are going to be guided by the definition of reasonable cause within the parameters of the common law. Now, the brilliant Attorney General, Madam President, in his wisdom, understands the parameters within police officers will have to operate. And as a result of that, was very mindful to include that provision in this particular section of the bill. So while we are increasing the police powers, we are doing it within the parameters of reasonable cause.
Minister, if I could just ask you to lower your voice a little.
Yes, Madam President. I'm surprised Mr. Roberts is not here. Senator Roberts. Madam President.
Senator Lyda, please desist. Continue, Minister.
Yes. So, Madam President, that in essence is one of the major reasons why 15.1, I believe, was crucial for me to at least explain, so that at least we can place into the public the understanding that we are not simply giving the police an unlimited amount of powers. They are going to be restricted by the definition of reasonable cause within the parameters of the common law, settled common law that exists in our jurisdiction. Now, the Attorney General, Madam President, would have indicated that there are amendments which will be brought to 15.3. So I will not look at that. I will now respectfully take my colleagues to 15.2 of the bill, which is before us. Now, 15.2, clause 15.2, Madam President, I'm dealing specifically with the issue of constitutionality here. Now, clause 15, subsection 2, goes on to say that a magistrate under his hand may issue a warrant to a police officer authorizing the police officer to enter and search a dwelling house where a magistrate is satisfied on evidence on oath that there is reasonable ground for believing that there may be found in the dwelling house a gang leader and so on. Now, again, if I may address my colleagues to another case. There's a case of Central Broadcasting Services versus the Commissioner of Police. This particular case, Madam President, went on to quote another case by the name of DPP and Barnes. This case alluded and explained what was the concept of a dwelling house. And it was noted that a dwelling house is much more, Madam President, than brick and mortar. It is a home of a person, and it must therefore be afforded protection in law. Now, because, again, as legislators, we have recognized that a house and a dwelling house ought to be treated very differently. Even though, again, while we are giving the police increased powers, we have ensured within the parameters of this legislation that the powers that the police has is limited when it relates to entering into someone's dwelling house, recognizing that that is where we may trip over issues of constitutionality if we just tell the police, well, yeah, you could ride up on a man going to his house and do whatever you want, right? So we have made provisions within 15.2, Madam President, as it relates to dwelling houses. If I now may analyze and make a contribution, Madam President, to clause 16 of the bill which is before us, and this particular section, Madam President, this clause deals with the issue of detention. Now, clause 16.1, Madam President, it speaks to the powers of police officers to detain a person without a warrant for 48 hours. The officer, as stated in the bill, must have reasonable cause to believe that the person who he's seeking to detain has committed or is about to commit an offense. And we all have seen the bill, so we know what the clause reads. Now, Madam President, I understand that the detention of a person, it may be argued, is a prima facie tortious case. And some may argue that it's even an infringement on Section 4A of the Constitution of Trinidad and Tobago, and that speaks to the right of a person to liberty. Now, Madam President, I submit respectfully that the justification for 48 hours and the police's ability to detain for 48 hours can be found and is referred to in several international comparators. So, for example, if we look at the general comment number 35, Article 9, called Liberty and Security of a Person of the International Covenant of Civil and Political Rights, we see in that particular article, 48 hours to detain someone was deemed as reasonable and not being unconstitutional. Another international comparator, Madam President, is the recommendation Reg 2006 in brackets 13 of the Committee of Ministers to Member States on the use of remand in custody, the conditions in which it takes place, and the provisions of safeguards against abuse. That's a very long article. This came out of the European Council. This is another international comparator that spoke about the 48 hours not being unconstitutional to remand someone, to hold someone, clause, if I may respectfully read Rule 14 of this particular international comparator, it stated that the lapse of time between the detention of an individual and the individual's rights to appear before a judge should be no more than 48 hours. It was stated that the interval between the initial deprivation of liberty and the appearance before such an authority should preferably be no more than the 48 hours, and they recommended 48 hours as being a sufficient time frame. So that's international comparators. So in Trinidad, by presenting this bill and speaking to the 48 hours, we are not departing, Madam President, legally from what the international position is. Even if we look at case law, we have the case of Dallison and Caffrey again. That particular case, Justice Stallmeyer in particular, said that while there is no statutory provision restricting the period of detention, in his wisdom, he alluded to the use of 48 hours as a guideline. So again, by us including the period of 48 hours, it is within the parameters of this bill, it has not departed from what learned judges in different jurisdictions would have alluded to. Even recently, Madam President, Justice Lisa Ramsumir-Hines, I distinctly recall, in a written ruling dated the 1st, 2019, I believe it was a matter of the application of Dinesh Durga for the detention order. I believe it was under section 17.4 of the previous Anti-Gang Act. That was the 2018 Anti-Gang Act. Now, the clause in which he challenged was the section which Dinesh Durga challenged was section 17.4 of the 2000 Act, and that is now clause 16.4 of the bill which is before us. And Justice Ramsumir-Hines, in her wisdom, she said inter alia that 48 hours is a maximum period that can be used for detention. She also advised, and from the judgment, she advised that in cases of all the detentions under this act, within the first 48 hours of arrest and detention, the police should be acutely sensitive to the need to conduct their investigation diligently and expeditiously, and went on to give some suggestions as to what the police should do within those 48 hours of detention. Now, what is incredible is that if we read lower down into this section 16, for example, if we look at section 16.3 of the bill that is before us, we have legislated what the police is now required to do during that time of detention. So Justice Ramsumir-Hines would have made mention to this since in 2019, and in this bill, we have legislated that. So we are saying to police officers that while you're detaining a man or woman for 48 hours, these are the checks and balances, these are the things that has to be done during that period of detention. And that is alluded to, as I said before, Madam President, in section 16.3 of the bill which is before us. Now, if I may take my colleagues to clause 16.4 of the bill. 16.4, Madam President, it gives the police the right to seek an order for continued detention beyond 48 hours, where it is necessary for preserving evidence and all of that. Now, this also practically is a fundamental and very important provision in the bill which is before us, that provision where the police now can knock on the door of the court if 48 hours has lapsed. And and it's very important from a very practical perspective. So, for example, you may have cases where the police may arrest someone on a Friday evening. You take them down, let's say under this bill, if it becomes an act. And you carry that person down, but you have not been able to proffer a charge yet because you're still in the process of conducting an investigation. Now, to be able to lay a charge, what may be required is some forensic evidence, some ballistic evidence. You may require a substantial amount of evidence to be returned to you as police officers before you can actually proffer the charge. What this extension does, sometimes to get that evidence now may exceed 48 hours, and that's why I use the weekend scenario. So sometimes you might take down a man, you take him down on a Saturday evening, and it's difficult to get a forensic report or it's difficult to get a ballistic report within that 48 period. So what you have now is the police now, Madam Deputy President, Deputy President, is that Vice President, what we have is there is now an opportunity of the police to knock on the doors of the judicial officer asking for an extension of time beyond that 48-hour period. And this is absolutely crucial in a practical sense. And therefore, we have to, again, commend the Office of the Attorney General. We have to commend the Attorney General for, in his wisdom, including this provision for an extension of time. I mean, even as lawyers, we find ourselves sometimes in a bind. In civil matters, for example, we have a 28-day period to file a defense. And sometimes there are just circumstances of evidence coming in late, the client is unable to get information to us, that we are required to knock on the door of the court, ex parte as well, to make an application for the court to grant us, for the court to decide whether they're going to grant us an extension of time. I think it was Senator Lakshmi Dayal spoke about her concerns about the ex parte application. And even at a high court level in civil matters, we can make ex parte applications, and it's for the court to decide, it's for the judge to decide, based on the application that is before him or her. If it is one, and I have seen where I've made personal ex parte applications, and a judge may look at the evidence or the application and say, no. I need the two parties to appear before me before I grant whatever it is that you are seeking ex parte. So we have not locked out in this particular, even though we have said in this provision that an ex parte application can be made. An ex parte is an application for the public. It's an application that can just be made with one party appearing, not both parties appearing. Even in an ex parte application scenario, a judge still has the discretion to decide that, okay, I'm looking at the facts, and I don't think this is sufficient evidence. I need both parties to be present in this particular hearing. So this is to elude any concern, because people may hear the word ex parte, and not understand what we're talking about. Certainly, we're not tripping over any constitutional rights of anyone by saying that this application for further extension of time can be made by an ex parte application, Mr. Vice President. So this is as it relates to Clause 16.4 of the bill that appears before us. If I may now respectfully take my colleagues to Clause 6 and Clause 13 of the bill which is before us, I personally am very, very happy and in full support, 100% support. I guess being a past teacher, being a mother of a young boy as well, for this particular provision, because it refers to the recruiting and coercing of young people into gangs. Now, I would like to consider, as I said before, this Clause 6 of this bill, in conjunction with Clause 13, as it provides for the recruiting of a gang member. Now, Clause 6 specifically states that a person who coerces, encourages, entices, aids, and abets another person to be a gang leader, a gang member, commits an offense and is liable on conviction and indictment to imprisonment for 25 years. Clause 13.1 goes on to speak about a person who recruits another person to a gang, commits an offense and is liable on summary conviction to imprisonment. And then Clause 13.2 goes on to speak about a person who recruits a child a child to a gang also commits an offense, and it speaks to what they are liable for. On a summary conviction, to imprisonment for 15 years, or on a conviction, on indictment, to imprisonment for 25 years. Now, this particular provision in particular, it pulled every single heartstring that I have as it relates to child offenders, as it relates to persons preying over children and trying to coerce children into joining gangs. And the reason for this is because I'm not sure if any of us recall the case of Joshua Andrews. And Joshua Andrews was a case in about 2018. And my father at that time, he was the senior superintendent for the Northeastern Division. He was in charge of the entire division. And my father, for most of my life, was for my entire life, he was a police officer. At that time, he was in charge, as I said before, of Northeastern Division. And it was the first time in my entire life I ever saw my father came home after a matter dealing with an issue, and he looked totally winded.
Senator, you have 5 more minutes.
Yeah, thank you very much. It was as if he could not contain himself. And that particular matter, while he was not the investigating officer in the matter, the child who was killed during a gang crossfire, which is Joshua Andrews, attended a school which fell within the Northeastern Division. And my father would have had to go to that school to counsel some of these children. And I will never forget, he came home and he said, "You ever hear somebody cry from their belly? You ever hear somebody cry because they're feeling pain from their belly?" And I think, and it was because the children, the other students in the school who had known Joshua Andrews, that had affected them, that assault and that murder of that child had affected them so tremendously that not even my father, who had so many years of experience, could have handled that. And this particular clause, I respectfully submit, it has the ability to protect our children. It has the ability to protect those little boys who do not have the ability to protect themselves. There are many young men outside there, we all understand, that they lack father figures in their households, and they turn to gang leaders because they feel a sense of belonging. It is our responsibility as a parliament to protect those who cannot protect themselves. And I'm saying this to ask my learned brothers and sisters of the independent bench to give our government the full support in this anti-gang bill. Yes, the statistics may not show an insurmountable amount of convictions, but it could certainly play a part in suppressing criminal activity. It can certainly play a part in suppressing gang activity in this country. It is our responsibility, I respectfully suggest, and I will continue to say it, to protect those who is not in a position to protect themselves. And I'm asking my colleagues, the honorable senators of the independent bench, to please, notwithstanding, yes, we may need to amend certain parts of the bill. The Attorney General said that he's open to conversation. But the possibility of suppressing gangs and saving a child who cannot save himself because the adults who were supposed to save him did not save him or did not protect him, we may very well be able to do that with this bill that is presented in the Senate today. So to that extent, I know I did promise that I would respond to some of the comments made by Senator Mark. I know Senator Mark said that this government, we're dealing with law and we're not dealing with the social issues as it relates to young people. I would say that this government didn't only just develop a social program to help young people. We created an entire ministry to help and save young people. And that ministry is found in the form of a Ministry of Youth Development. I know Senator Mark spoke about his theory on SRPs and all of that. I want the record to reflect that the recently passed SRP and PCA bill that was brought and passed last week in the House, it was our intention to put SRP, it is the intention of that law to place SRPs on the same footing of even police officers. I know he quoted some statistics, but I also have stats which I want to put in the public record. For example, in the Trinidad and Tobago Police Service, we have an audit of 524 male officers, 1,859 female officers, as opposed to the SRP audit, which for males, there is 357 part-time male officers and 242 female officers. Also on the SRP audit, and this I need to place in the public record, is that for male officers, full-time male officers, there's 2,913 officers and 864 female officers. So in total, the TTPS, we have about 6,983 officers, whereas the SRP, there is 4,376 as the total figures. Now, Senator Mark, I recall he made a recommendation as to amendment that he wants the police to provide the report, the station diary extract or something to that effect. He wanted us to legislate that. I want Senator Mark to know that under the standard process of disclosure, this is allowed. So with these few words, I fully support this bill, and I ask the learned colleagues of the independent bench to give us the support that we require. Thank you very much.
Senator Leiter.
Thank you, Mr. Vice President. Mr. Vice President, today we come to this honorable House to bring justice to those who have lost loved ones via gang-related activities. Today we come to this honorable House to give the youth of this nation a fighting chance in surviving in the recruitment into a life of crime. Today we come to this honorable House, Madam President, and we should be putting aside politics to give Trinidad and Tobago a hope for the future in reducing crime. And Mr. Vice President, the opposition is always pleased to participate in any legislation that will deal with the scourge of crime. However, Mr. Vice President, the opposition proves from time and time again that we will not simply support blindly legislation which on the surface appears to fix the issues related to gang-related matters simply by the name of the bill. But rather, we will support good law in the best interests of the citizens of Trinidad and Tobago. So, Mr. Vice President, during my contribution, I will demonstrate some of the challenges of implementation with this bill, which were anchored in Clause 5 and 6 as it pertains to sentencing and coercion, Clause 11 and 12, harboring and concealing a gang member, Clause 15 and 16 regarding the challenges of the TTPS, as well as the ability of the TTPS to fulfill their duties that they are given in this law. But, Mr. Vice President, we heard the Attorney General state that this is being passed by a simple majority, because he stated that we, the opposition, would simply go against it, that we would not agree with this law, Mr. Vice President, giving the impression to the people of Trinidad and Tobago that we don't care about crime. And I can't let that comment pass lightly, Mr. Vice President, because I must make it abundantly clear to this Senate, as well as to the population of Trinidad and Tobago, that I, for one, am committed to any sensible action that will deal with reducing crime. I don't want this, I don't know, Mr. Vice President, if the government can say the same. Because, Mr. Vice President, we have a Minister of National Security who is on record publicly stating that he's not responsible for crime. Mr. Vice President, one only has to look at the Express online on January the 20th, 2020, when it reads, Minister of National Security Stuart Young says he's not responsible for crime and does not need to find excuses for the current spate of crime. We didn't go on record in the paper saying that, Mr. Vice President. What kind of leadership is that? We all belong to Trinidad and Tobago, and it is all of our responsibility to fight crime. All of us inside of this house, all of us on both sides, and in the independent. It is the responsibility of the police service and other bodies who are responsible to fight crime to deal with crime. It is the responsibility of NGOs and the private citizens of this country to assist and report when they see crime and gangs in this country, which some of my colleagues will speak more about it in terms of the social aspect. Mr. Vice President, the average citizen has their part to play. But unfortunately, we are saddled with a Minister of National Security who does not believe he has the responsibility of crime. So, if that is the view, then what is left for the rest of us? Mr. Vice President, in contributing to this anti-gang bill before us here today, We have to look at the history for us to understand where we came from and where we are going. Let us not forget it was the United National Congress-led government in 2011 that introduced this anti-gang bill, because we saw the need for legislation that would deal with gang activities in this country. But Mr. Vice President, you see, in any bill, passing any bill, and beyond that, the devil is in the detail, Mr. Vice President. Mr. Vice President, Senator Lakshmi spoke in grave detail about the legislative side of this bill. She went to great lengths to show some of the shortcomings. I think it was also, and Mr. Vice President, the issue I have here today is the fact that we are coming once again, and if you permit me the latitude just to make the context for the rest of my speech, we've come here today to pass such an important piece of legislation by a simple majority. And we want to know something as serious as this. Why is it not being passed as a special majority? Mr. Vice President, the Attorney General himself has admitted by his own comments that he's had to water it down to bring it here, to pass it here today by a simple majority. So why are we here debating this? Mr. Vice President, when we look at when they bought the Proceeds of Crime Act in the bill under Section 17 to justify the removal of the special majority, we take note, Mr. Vice President, that the Proceeds of Crime Act was in fact a special majority law. So no amount of smokes and mirrors that you introduce into this House will prevent us from exposing the craft in silencing and nullifying the voice of the opposition. Our duty in this honorable House, by mandate of the people of Trinidad and Tobago, is to call out the government and keep the checks and balances there. So, Mr. Vice President, I'm saying that this bill should be passed by a special majority. The Attorney General himself has said he is going to be open to amendments. And he said he will be open to amendments to the independent side, to the opposition side, every side. I think I also heard Senator Vera brilliantly say it, that we should all be coming here and working together with amendments to pass good law. So what is the fear of passing this by a special majority? If the Attorney General is so confident and his colleagues are so confident that the law is in fact good law, and that he will be giving the opportunity of all sides of the House to contribute, then he should take away this simple majority and pass it as a special majority, Mr. Vice President. Mr. Vice President, I told you that the devil is in the detail. And I won't be repetitious in quoting all the different issues within the bill. I will look at another part of the detail, because I think it was Senator De Freitas himself who said that, that quoted or made reference to Senator Lakshmi. Senator Lakshmi also made this reference, that no law can be executed successfully unless the protective services are properly resourced. I think Senator De Freitas said that it was a cutout, but in my humble opinion, it is a reality, Mr. Vice President. Let us look at the details when it comes to resourcing. Mr. Vice President, Clause 15 and 16 of this bill adds a burden to the police service in treating with the offenses under that act. That being said, I am concerned about the matter in which the government has treated with the resources of the police service. Mr. Vice President, as recent as last month, we saw the Commissioner of Police before a Joint Select Committee of Parliament stating that they were up to $182 million in debt to suppliers. But I want to make reference to a Newsday article on Monday, the 15th of February, 2021. They reported this to the public, Mr. Vice President. And it said that the Commissioner of Police, Gary Griffith, said on Monday, the police service continues to function at optimal levels despite owing suppliers $182 million. And Mr. Vice President, he said the Finance Minister, Colin Mimbert, and the National Security Minister, Stuart Young, are doing all they can do to deal with that debt. That was in the middle of February Mr. Vice President, nothing has changed. You'd be at pain to know that nothing has changed. And while the Commissioner has given us this assurance that the operation of TTPS will not be affected, because we know he goes out there and fights every day with the members of the Trinidad and Tobago Police Service to the best that they can. I'm concerned that if the government does not address the issues of resourcing the police service, then this law, Mr. Vice President, will all be in vain. This will be in vain. And I will describe what I mean by that as I go along, Mr. Vice President. The Commissioner should not have to be begging suppliers not to pull the plug on basic services, such as the repair of vehicles, fuel, electricity. Mr. Vice President, there was a video circulating of a man trying to make a police report in Matlot. And when he reached there, the two police officers were outside under flambeau. The man said, nah, this can't be for real. He turned around and gone. What if that was a report on a gang? About information pertaining to a gang that this bill could address? And the man turned around and walked off. I mean, I'm not trying to be facetious. It is indeed a serious matter, Mr. Vice President. When we look at all the other operational equipment or other services that allow police officers to execute their job in an efficient manner, I heard that the Attorney General said when he was coming to the House to say, to the Senate to say that he was going to amend 15.3, I think I heard him say that in their rush to present the bill, they didn't get the time to send the amendment. Well, I'm saying that the Attorney General should not be rushing this bill. And I ask that the government first clears the debt of the police service, who officers put their lives on the line every day to protect us, so that this bill would make sense if passed, or when passed, because they will pass it by a simple majority, Mr. Vice President. So, given all of that, I do commend the TTPS for working on such a shoestring budget. But, Mr. Vice President, I also heard Senator Vera speak about tackling crime with a holistic plan, a master plan. Well, I humbly submit and say to Senator Vera, this master plan requires resource. It requires resource from the government, not just coming here to read out some clauses and pass this bill. It requires resource, Mr. Vice President, for this holistic plan. So in the spirit of members giving statistics here today, I want to give some actual facts and figures here, so that those on the other side, when they're ready to, when this is actually passed, that they understand what is necessary to make this law work. When you look at the, Mr. Vice President, these figures are alarming, to say the least. The TTPS allocation for goods and services, Mr. Vice President, in fiscal year 2020 was $515 million. However, the TTPS releases for 2020 were approximately $335 million, some $180 million short, putting the TTPS in a debt of over $150 million to contractors and providers who will be playing a part in assisting the TTPS to execute these laws. Mr. Vice President, it gets worse. As for fiscal 2021, the TTPS was allocated a meager $324 million, just short of $200 million less than the year before. How can the TTPS be expected to be effective when they can't even get, when their budgets are being cut? And Mr. Vice President, I'm sorry to break this down to the most ridiculous. To date, the TTPS has received 6 months into the year. The TTPS has only gotten releases of a meager $58 million. And as per the financial regulations, Mr. Vice President, they need to use that money to pay the debts of the year before. So, Mr. Vice President, in truth and in fact, the TTPS is broke. It is also understood, Mr. Vice President, that the Honorable Minister of Finance had received approval to utilize a loan for the TTPS to cover the outstanding bills from 2020. Again, there's been no releases. Mr. Vice President, we are debating a bill here today that requires the police service being effective, and they're not provided with the resources to do so. The TTPS is therefore running on goodwill and credit, which will shortly be stopped, as a number of service providers simply cannot sustain this any longer, Mr. Vice President. How can police officers respond to certain matters? When we look at clause 15 and 16 in this bill, should the TTPS get information about a gang leader or a gang member and is there to use 15 and 16 somewhere in ARIMA, Mr. Vice President? When you hear the fact that more than 30% of the vehicles of the TTPS are now broken down, more than 1,700, what are the TTPS going to do? They get the information on the gang, what? Jump in a red band maxi and go down the road and hold the criminals and bring them back? Then jump in a maxi and go to the court? Mr. Vice President, another resource problem seen here is this matter about the automatic fingerprint identification system. It has come to my attention that currently this system is not working. And this is as a result of the TTPS being unable to pay for the fees of this system. So this system currently, this automatic fingerprint identification system, is literally shut down, Mr. Vice President. So we haul in 15 gang members under many of these provisions in the schedule, and we open the drawer, pull out the whole, I think Senator Sagram Singh Suklal can talk to her father.
It's Minister.
Minister. My apologies. Can speak to her father for him to remind her about when he's open the drawer and pull out the little thing of ink with the roller. So we go roll with fingerprints and go again. This is gang members we're talking about, you know. But Mr. Vice President, the one that gets me is the recent reports coming out of the TTPS that they don't even have toners for their printers in the police station.
Okay, so Senator, I've given you quite a bit of leeway. I'm assuming that, because you've spoken about the point of resource to the TPS at length, given several examples. So I'm assuming now that you have another point you want to generate.
Yes, and it is regarding resources, but I will change the point. I will bring it to a different angle now. But if you just allow me to say this last part, because I think it's very pertinent. Because the Attorney General did mention, so I'm coming from what he's brought to the debate, he has mentioned that they are looking at changing the definition of the law enforcement to include SRPs and so forth. And I believe this would be to help to resource the police service so that they can fight these gangsters. But my understanding, Mr. Vice President, is that funds that were allocated in the budget for the recruitment of police officers, I think it was reported, 300 police officers every 6 months per batch. This has not been provided to the TTPS. So the TTPS, with officers retiring, cannot even bring in regular officers into the fray. And maybe that is why Senator Mark was so passionate about the SRPs, why he spoke so at length about the SRPs and what could be formed now. We're not bringing regular police into the service, but we bring in SRPs. But Senator Mark has already went at length on that. But Mr. Vice President, another issue of resources for the national security entities that presents this bill from being effective as it should. When you look at the extreme powers given to officers as seen in clause 16 and 17 to protect the innocent from the few and the very few, because we know the Commissioner of Police has weeded out many of them, but for the very few unscrupulous officers who will be using these clauses, we get concerned when we don't see the resources put in place to protect the innocent. So when we hear, and I hope that satisfies you as a different angle, Mr. Vice President, because this is important. Because this bill affects innocent, could potentially affect the constitutional rights of citizens who may be innocent. When we look at 800 cameras, CCTV cameras broken down, when we look at the collapse of the DNA investigation unit due to the lack of funding for crime scene and forensic investigation consumables, when we look at the fact that there is a DNA lab that has not been commissioned or approved to be commissioned private or a government entity that is a DNA lab, when we see that that's not there, when we see the lack of resources for the crime scene investigation, and especially, Mr. Vice President, as referred to in this same article, that on Monday the 15th of February 2021, the Commissioner of Police stated, and I quote, "Once the police receive funding they need, Griffith vowed to make it mandatory for officers in all the frontline units to have body cameras." Mr. Vice President, this is important, especially when we hear people, the citizens of this country, complaining about the possibility of police brutality or a few unscrupulous police officers taking advantage of them. So we don't see resources put in place to protect these people. Because, Mr. Vice President, every police officer is empowered with this bill. Everyone from Constable Brown to Inspector Boy Blue coming with or without a warrant to arrest you. We will see if they get a warrant. But, Mr. Vice President, many of us remember that song, that reggae song. But why it's relevant here? Because it tells the story of an unscrupulous police officer who beat a man till his eye was black and blue simply because he said, "What the police will do." So where is the resources to protect our innocent citizens when we pass this piece of legislation here today, Mr. Vice President? Another very important matter, Mr. Vice President, as it pertains to resourcing our borders, or our porous borders. And this is a completely different topic now. Mr. Vice President, in the list of offenses in the first schedule, item number 30, I think it is here, 30. Yes, number 30. Under the Trafficking in Persons Act, rises the question of our porous borders. Therefore, this bill cannot be considered in isolation. I once again tie the resources of our protected services at the borders to this bill. Because this bill standing alone by itself simply cannot stop this activity. We see, Mr. Vice President, national security vessels parked up, a lack of patrols, a lack of diesel, and the government starving the national security apparatus of needed resources in this regard. This breaks this bill down in this matter simply as a plaster to a sore. Mr. Vice President, one matter which disturbs me in contributing to this bill is that we are now in a predicament in our country being the host for Venezuelan gangs. So it's not just local gangs now, Venezuelan gangs. So I want to ask the Attorney General, how does this law prevent this situation from gangs coming in through the porous borders? We recall the notorious gang leader of the Venezuelan Evander gang, one Mr. El Culon, who was held in Trinidad with guns and ammunition and was sentenced to prison in June of 2019. So we have a situation where Venezuelan criminal gangs have now migrated into Trinidad and Tobago and therefore increasing the criminal element burden on our country. We also note that the anti-gang bill was not needed to apprehend him, or detain him or convict him. However, should we apply the anti-gang bill as proposed under Clause 5, where the maximum sentence is 25 years, we would encounter a challenge of an increase in the sophistication in criminal matters of those convicted. That rehabilitation component of our correctional facilities may be blunted by the super criminals from across the Gulf, mixing with our local population for a possible of 25 years, literally making our prisons a university of gangsterism. Therefore, I ask the government, I think I heard the Attorney General talk about incarceration and the prisons. Is the government prepared to put a separate facility for those international criminals when they are caught by this anti-gang bill. And I put it to the Parliament today that should be something that should be debated, if not now, in a subsequent bill. So, Mr. Vice President, the members of the Evander gang are here. One would have to assume that they are here illegally and perhaps looking for jobs in the construction sector while they are also engaging in drugs and gun trafficking and so forth. But they may have co-opted legal Venezuelans, migrants, into this gang structure. So I make an appeal to the Minister of National Security and the government to look into this matter urgently. We can have Venezuelan gangs infiltrating the Trinidad and Tobago communities and forming cells in every community. And I'm going to get to a point now about the Venezuelans creating the cells.
Senator, you have 5 more minutes.
Thank you, Mr. Vice President. This will surely be captured under Clause 6 of this proposed legislation under seeking to coerce persons to join a gang. But these international gangsters can be caught by other existing criminal legislation, as well in particular when it comes to the panchat of trafficking in guns and narcotics. Mr. Vice President, it is a recipe for a disaster, and we hope it's not too late. In fact, currently going on now, we see the re-registration process of Venezuelan nationals under the Ministry of National Security. It's just begun. So I am going to ask the question, what is the government doing to screen those persons that are being re-registered to ensure that they are not gang members and don't have the ability to bring gangsterism to Trinidad and Tobago? Is there some Interpol report? Is there communication with the authorities in Venezuela? I don't know. What checks and balances are being done? How much resources are the TTPS getting to deal with these gangsters? Because, Mr. Vice President, many of them speak simply one language, and that's Spanish. And so, does the TTPS have the resource to deal with Spanish-speaking gangsters in this country? We pick up these gangsters under Clause 11 and 12, and we catch persons in gang activity. Do we have officers, or do we have somewhere or resources to be able to deal with them in Spanish? To be able to deal with infiltrators who infiltrate into gangs, to report back to us, whistleblowers? Do we have those persons? I don't think the government is taking how seriously the porous borders is to this gang problem we have in this country. And so that is a matter of resourcing, Mr. Vice President. And it's a matter because, Mr. Vice President, the workforce in Trinidad and Tobago is already saturated with desperate Venezuelans. And this, therefore, represents an opportunity for local gangs and or Spanish gangs, for persons who are willing to come on board because they are desperate. They have no money. So while we have the Evander may be the first Venezuelan gang to be shown in our countries, others will surely follow if measures are not put in place and the borders are not resourced properly to stop the influx of illegal Venezuelans in this country. So I'm saying that this anti-gang bill is not enough to deal with the issue of Venezuelan migrant gangs. In 2019, when El Colon was arrested, the anti-gang legislation was in place, but he was not charged under that, but rather under the possession of illegal firearms and other charges. So, Mr. Vice President, as I conclude, I have shown during my contribution the challenges of implementing this bill that were anchored in clauses 5, 6, 11, 12, 15, 16, and the inability of the TTPS to do their job without resources. But one wonders, why is the TTPS and why is the Commissioner not being given this support? I mean, maybe they intend for him not to be there in a year's time. We'll see. This bill on its own will not bring an end to crime. The government will struggle to identify anyone they have convinced anyone about this bill bringing a total end to crime. We are not against bills to crime. We are for good legislation. But we are also for this government bringing, as Senator Vera said, a holistic approach to fighting crime. So, Mr. Vice President, I call on this government to stop bringing plasters for a sore. Ensure proper funding for the protective services in this country. Ensure this bill being passed by a simple majority today can actually be implemented. Because bringing law alone and in isolation will do nothing to reduce gangs and crime in this country. You see, I listened attentively to Senator Sagram Singh Suklal, her story about defending this 14-year-old child. But it seemed like when members on that side joined the PNM, Mr. Vice President, they finally find God. So I will say to the government, instead of only bringing this bill to the Parliament, they should be focusing on how that 14-year-old boy became a criminal in the first place, Mr. Vice President. Preventing 14-year-olds from turning to crime. And Mr. Vice President, the government could start that by giving our children laptops at school, Mr. Vice President. And with that, I thank you.
Senator Heath.
Thank you, Mr. Vice President, for the opportunity to contribute on this bill, short title of which is the Anti-Gang Act 2021. Mr. Vice President, let me say that gangs and gang-related activity is real. And what I've gotten from all the speakers so far is that there's a general consensus that it is a scourge in our society that presently exists. It would be perhaps true to say that the level at which gangs and gang-related activity exists is not mirrored by the detection, or it's not mirrored by the number of convictions in relation to the legislation that has been in place in the past. But having said that, I'm of the view that we must look upon the proposed bill and say to ourselves whether or not this proposed bill is so egregious or so offensive to civil society that we ought not to support it. I agree with my colleague Senator Richards when he stated that it's untenable that in 2021 we would not have legislation in place to deal with gangs. At the same time, we simply cannot have legislation for having legislation's sake. And that's why I would have alluded to the fact that we simply cannot pass anything and call it anti-gang legislation. I am of the view that this is not any piece of legislation. I'm also of the view that perhaps the reason why the detection rate is so low and the conviction rate as well has more to do with the intelligence and information gathering that presently obtains. And once we get a better handle with respect to intelligence and information gathering, we can see more productivity in the area of the detection. Now, I propose not to be too long, simply because coming at the tail end of the lineup, a lot of my colleagues would have echoed sentiments that I wanted myself to say, but to avoid repetition, I would simply look to those clauses for which I perhaps have a slightly different take from what would have been advanced, and so that I would leave out those so as not to be repetitious. The first one I want to touch on is Clause 5. Clause 5, when it is read, 5.2, a person who commits an offense under subsection 1A is liable on conviction and indictment to imprisonment for 25 years. 1A is a gang leader. There seems to be a deliberate attempt to make a distinction between the offense for a gang leader and the offenses which follow for a gang member and persons who perform an act as a condition for membership in a gang or professes to be a gang leader or a gang member. Now, that's all well and good, because usually when offenses are strictly indictable, it's because they are more serious type offenses. However, what happens in actuality when several persons are arrested for gang-related offenses, you can have one being a gang leader, one being a gang member, and they share the common offense of being involved in a gang-related activity. However, if one is indictable only and the other one can go by way of summary, what you may find happening is there may be a split where the person who is charged as a gang member with the gang-related activity will have a summary trial, and the gang leader for the same gang activity will be tried on indictment. You will have the same set of factual matrix, and the resources of the state will be stretched. So what I want to suggest with respect to this is that, and I think the learned Attorney General had alluded to it, is that with respect to the 5BC, all the offenses be laid indictably, and if needs be, those offenses can be hybrid, so there's the option for it to be done summarily. But a prosecutor, seeing persons charged together, gang leader, gang member, and one offense of a criminal activity which can be done jointly, is not likely to recommend, because the recommendation has to be made by the prosecutor for it to be done summarily, is not likely to make that recommendation if he realizes that there's bound to have two sets of trial, but a preliminary inquiry and a trial, and so that the prosecution will have the say on that, having regard to the combination of persons that is before the court. Mr. Vice President, if I may now take you to Clause 10. Now, I know my colleagues have stated that it's in effect Clause 10.2 is a reverse burden. I support that view, that there is a reverse burden. And it's not that a reverse burden is anything new in legislation. However, what must come before the burden is reversed is there must have been a clause which creates a legal presumption. Now, I think my colleague Senator Vera would have alluded to 1B, creating the presumption. I don't agree with that. 1B says a person who has in his possession a bulletproof vest, firearm, ammunition, or prohibited weapon, which he ought reasonably to know would be used in the commission of a gang-related activity, commits an offense and is liable on conviction on indictment to imprisonment for 15 years. Now, I don't agree that that creates a legal presumption. Possession, as we know, well, not as we know, sorry. Possession can be constructive or actual. Possession here essentially refers to either one or the two. Either one, sorry. It's either constructive or actual. A presumption is not created here because there's nothing akin to, and the best analogy I could find right now is a deeming provision, which is akin to Section 21 of the Dangerous Drugs Act, where you're deemed to be in possession if it is found in dwelling house, vessel, vehicle, you're deemed. So that creates a legal presumption which is rebuttable. And so what you then have is the reverse burden placed on the defense to show that the offending thing, was not there with his knowledge or consent. So that is a persuasive burden which reverses to a defendant on the lower burden, which is a balance of probabilities. So with respect to 10.2, it seems to me, this is my view, that a burden exists sort of in a vacuum because the presumption has not been created before. And so it is, Honorable AG, is just something to look at, whether or not you need to create a presumption first or it's even appropriate in these circumstances. So for instance, for firearms and ammunition, I could well see, I think with respect to possession of a bulletproof vest, that is an offense. I can't remember the exact offense now, but it's just to look at that area and see whether or not you need to create the presumption first before you reverse the burden. Similarly, the same thing would apply to Clause 11.3, which says it's a defense for persons charged with an offense under subsection 1 if he proves that he did not know or could not reasonably have known that the person he was harboring was a gang leader or a gang member. You're reversing a burden, and I'm saying that I'm not seeing the creation of the legal presumption for which the burden ought to be reversed. Of course, Honorable AG, what you need to consider here is that when you have a reverse burden, essentially, at trial, your right to silence is taken away. Because, for instance, if the presumption is created on the case for the prosecution, and you do not go give evidence, then essentially you will be found guilty. So, again, like the deeming provision in the Drugs Act, if you're deemed to be in possession, drugs found in your home, if you don't give evidence in those circumstances to rebut the presumption, then you're going to be found guilty. So your right to silence is also something that comes into play here, and that's why we need to get it right in that regard. If I may now go to clause 15(1). A police officer may arrest without a warrant a person whom he has reasonable cause to believe is a gang leader or a gang member, or who he has reasonable cause to believe has committed an offense under this act. Now, reasonable and cause has always been the test with respect to arrest. So nothing is created when we say reasonable cause here. What I have some consternation with Honorable Attorney General is the without a warrant, and I will tell you why. If police are aware of persons for whom they have reasonable cause to suspect, then they can go and take out a warrant. Now, what the warrant is, in essence, it's a safeguard which absolves the police officer from any suggestion of an arrest which has ulterior means. Because when you go for the warrant, you're entitled to go on oath and satisfy usually a magistrate in this case that a warrant ought to be taken out for the person's arrest. So that is a safeguard which I don't think we need to get rid of with respect to arrest. But it does not mean, for instance, and it has happened, if police were to see someone and they were to have reason to believe that that is a wanted person, there is nothing precluding the police from arresting that person, taking him back to the station to make an inquiry whether or not that person, in fact, has a warrant, is a wanted person. Similarly, if that person is caught in the commission of a crime, there is nothing precluding the police from going straight to arrest that person. He does not simply have to leave the crime scene, go and get a warrant, and come back and arrest him. So the law provides for that. But to do it carte blanche, to say that arrest without a warrant, I think the safeguard of the warrant absolving the police of any suggestion of... yes, please.
Thank you, Honourable Senator. Would you mind addressing your mind, as I'd like to hear it, as to how this runs in accordance with Section 3 of the Criminal Law Act for an arrestable offence, which is over 5 years? These offences under this Act all being over 5 years, where there is a liberty to arrest without warrant in the existing law, because I'm concerned about the collision between the two.
Yes, but you see, I was about to marry 15(1) with 16(1), where you want to further detain the person. And I'm suggesting to you that if you, in 15(1), if you arrest the person with a warrant, reasonable cause, then you need not trouble yourself about saying that you don't have a warrant here, because there can be no detention without an arrest. So the arrest is going to come first, right? So once you have reasonable cause, 10 out of 10 times you're going to satisfy the magistrate that a warrant ought to be taken out. The good thing about the warrant is it does not die, it does not extinguish. Once it's taken out, it could lie for years and years until the person is found. So it doesn't have a shelf life. So if the police are aware of persons, their name and their likely address, take out a warrant for them. So the next thing is when they see them, they simply arrest them. And it has happened in the past where police have arrested persons believing, reasonable belief, that that person has a warrant taken out for them. And it turns out that they're right. So it's not that, that's what I'm saying, it's not that you can't do it. The difficulty is, and I'm saying, it has been my experience, Honorable Attorney General, where persons have been arrested and released without a warrant. It happens. If you put it in legislation, let me say that it would increase tenfold. However, if the policeman knows he has to go for the warrant, which is the proper thing to do, that safeguards him, and he's not likely to go through trouble to get in a warrant for any ulterior motive, save and except that he really has reasonable and probable cause. So I'm just suggesting, I don't think you need to put in here without a warrant, because the warrant does certain things. And it lies there and it stays there until the person is found. And you could well imagine, if there are 100 persons for which there's reasonable cause to believe that they are gang or gang members, then take out 100 warrants and let it lie until those persons are found, bring them in, and hopefully the information you have gathered is sufficient to be converted to evidence, and it could lead to a charge, and then that person will have a trial. So that's why I'm saying, once, I suppose, Honorable AG, the fact that it's in black and white here, that without a warrant you can detain someone for 48 hours, causes me some degree of consternation. But I think that might be allayed by simply putting an arrest with warrant up at the top. Because then the police must have...
Senator, 1 second. I think Senator Vera wants to ask.
Direct your mind still on this clause 15.3 about the circumstances of hot pursuit, where a police officer believes a crime has been committed, the felon has run into a particular premises or place. He doesn't have time to get a warrant. And so this authorizes him in hot pursuit to gather that person, to go right away and seize that person. If you had to wait for a warrant, he will get away. Also, what about the situation where a crime is about to be committed? And again, the police officer is sitting there and he wants to intervene. He doesn't have the time to go for a warrant.
Yes, so I'm not sure if you were here when I had alluded to that, that if a crime is being committed, and similarly in the hot pursuit scenario, nothing precludes that officer from going to make his arrest. Nothing precludes him from going to make that arrest. However, what is contemplated here is outside of those scenarios. So that is what causes me some consternation. But even if you have warrants inserted here, in those circumstances, you simply don't leave a crime, go and get a warrant while the crime is going on. So you can do that. That's provided for. The law provides for that. So with respect to clauses 16.4, with respect to the ex parte application, I really don't have a problem with that because there is a provision for the person in detention to apply for discharge of that further detention. Actually, in the case of in the application of Sergeant Durga that my colleague, Ms. Sugram Suklal, had referred to, the detention was for further 11 days. And it was of a person who, Sergeant Durga, had done some good investigative work with respect to satisfy the court, who was not easily satisfied that in those circumstances, it was warranted to keep a man in police custody for 11 further days. So that I've seen it in operation, and because I suppose there was a high court judge, it was no easy task in coming before the court asking for that, particularly as it's not every day that is done. so that there's that safeguard. I have less concern with that. All in the round, Honorable Attorney General, I think this bill is a good foundation from which you can build on. As I have indicated before, that this type of legislation is required. There's just general consensus that there is a problem of gang and gang-related activity in Trinidad and Tobago, and legislation is needed. Legislation can be built on in time, and it's hoped that that is what will happen with respect to this legislation. And ideas could come forward. The Honorable Attorney General has indicated that he is certainly listening today, and he would have heard my colleagues on the independent bench, senators from the opposition, and so there's much food for thought that can go into coming back with the little tweaks that are needed to make this something that is palatable for all. Mr. Vice President, that is the extent of my contribution.
Minister of Tourism.
Thank you very much, Mr. Vice President. Thank you for giving me this brief opportunity to make some remarks on this anti-gang legislation. And like Honorable Senator Heath, I don't want to be too repetitious because honorable senators who've spoken before have all traversed the areas. And like Senator Richards, I totally agree that in modern societies where there is criminal gang problems, that those societies must have anti-gang legislation. So, Mr. Vice President, I adopt all the submissions of honorable senators who have spoken before in support of this anti-gang legislation. And I welcome the discussion as well, because as the Honorable Attorney General has stated, he's come here to listen, because government is intent on debating and putting forward the best legislation for society. This bill is no panacea. Strange word, it means cure-all, and I agree with Senator Vieira and I agree with Senator Lutch-Medial that this is no panacea for crime and criminality in Trinidad and Tobago. It is no magic bullet. This piece of legislation alone will not eradicate murder in Trinidad and Tobago. It will not eradicate rape, sexual violence, or violent crime. This legislation alone will not eradicate financial crime, money laundering, fraud, etc. What this legislation does is it makes it unlawful to be a member of a gang and to be engaged in gang-related activity. This legislation provides the tools for the police to suppress gangs and gang-related activities in society. And even so, Mr. Vice President, I dare say that this legislation alone will not even eradicate gangs, criminal gangs, and criminal gang activity. Not alone. And I respectfully submit that it is unfair to come to this debate and to suggest that in a short 30 months that criminal gang activity ought to have been eradicated. This piece of legislation that has, this act expired as it is, it was used and is to be used with other strategies to discourage membership into criminal gangs. It's just another tool to fight crime. And I agree with Senator Vieira. The way to fight gang crime, as suggested in the literature, you have three approaches. There is prevention, there is intervention, and then there is suppression. And suppression is what we're debating and treating with here today.
In terms of prevention, Senator Leiter said he hasn't heard anything about prevention. But Senator Sagram Singh Suklal spoke about the Ministry of Youth Development and National Service, an entire ministry formed specifically to deal with youth, young people, and youth development. We have strategies coming out of the Ministry of Education. There are strategies out of the Ministry of Social Development and Family Service. There are strategies coming out of the Ministry of Sport and Community Development. And I won't detain us with those here today, Mr. Vice President. But under the Ministry of National Security, there are a number of prevention strategies being undertaken, some by the police right now. We have the Trinidad and Tobago Cadet Force. That is a prevention strategy, targeting young people in schools into this military type of environment. We have community visits by the Trinidad and Tobago Police Service, where they visit members of the community and interact one-on-one with some of the vulnerable youth. We have school visits by the Trinidad and Tobago Police Service and other agencies such as the National Drug Council. Police youth clubs all over Trinidad and Tobago doing excellent work in communities to prevent young persons from entering into a life of gangs and gang crime. We have police town meetings. We have Trinidad and Tobago street talk. And in terms of intervention strategies, Mr. Vice President, we have pre-release partnerships where the Trinidad and Tobago Prison Service exposes their partnerships to expose inmates to pre-release programs where inmates serving the last 6 to 1 year of their sentences are afforded the opportunity to participate in programs, positive programs. There are post-relief partnerships as well that the Trinidad and Tobago Prison Service engages in to provide assistance to ex-inmates in alleviating unemployment and lack of proper living arrangements, drug rehabilitation programs, etc. So there are prevention and intervention strategies in a whole of government approach that are being undertaken as we speak. But this here today, what we're treating with is suppression strategy, anti-gang legislation. And Senator Richards is correct. Gang crime is not a Trinidad and Tobago problem. Gang criminality is not a Caribbean problem. It is a problem across the world in major countries. Major countries have problems curbing gangs and gang-related activities. And many of those legislatures across the world have enhanced their traditional laws and brought specific legislation, just like this, to treat with gangs and gang crime. And worse, Mr. Vice President, we have the problem now of transnational gangs, where gangs interact with each other, or gangs spread across borders. And Senator Leiter spoke about that with the Venezuela, the influx of Venezuelan gangs into Trinidad and Tobago. So how could you speak about that on one hand and then indicate that you will not support on the other? So Jamaica, United States, the United Kingdom, Australia, Canada, they all have very robust legislation to treat with gangs and gang crime. And we're not reinventing any wheel here. We're simply seeking to replace on the books, on the law books, specific legislation to treat with gang crime. And it's not the first time that this legislation was introduced. Senator Leiter admitted it today. This legislation first came about as UNC policy in 2010. And from that policy was born the Anti-Gang Act, that needed special majority support. And today I could say that in 2011, the PNM, all members of the PNM, supported that piece of legislation in 2011. So what has happened since then? The UNC brought that policy to deal with the scourge of gang crime, gang criminality, the explosion of criminal gangs in society. And society demanded a solution then, and they passed the legislation. So what has happened since then? When the UNC was in government between 2010 and 2015, you support the legislation. You worked with the opposition worked with you, and out came the Anti-Gang Act of 2011. But out of government, you have refused to support the now PNM government in passing anti-gang legislation. And then you wonder why people in society don't take politicians seriously. What has happened? And Mr. Vice President, you would think that the UNC would be the loudest voice in support of anti-gang legislation in 2016. Simply on the basis that under that UNC government that produced and foisted upon this population the life sport program that worked to proliferate criminal gangs all over this country under the UNC, you would think that the United National Congress and the opposition would be the loudest callers for this legislation, if only to correct the scourge that that life sport program caused in society. But no. Mr. Deputy Speaker, I adopt the submissions of yourself, Senator De Freitas, when he spoke, that the loudest call for this legislation is not the PNM government. The loudest call in society for this piece of legislation to be put back onto the law books, to be provided as a tool to combat gang crime, is the police service. And they are the best ones, the Commissioner of Police, the police service, they are the best ones to understand what is confronting them outside. They're the best ones to understand the resources that they have or they don't have, the efficiencies that they experience or that they don't experience. They are the best ones. And they have repeatedly called for the anti-gang legislation to be passed. They are on the front line. And yes, I wouldn't go into it, but within 3 weeks, the Commissioner of Police appeared before Joint Select Committee meeting, a public hearing, and repeatedly called for the tool that is the anti-gang legislation. Mr. Vice President, we've heard a lot of discussion around constitutional issues and concepts and principles of law said here today. But let's talk about the reality that is gang crime. And what exactly do these criminal organizations, what are they actually involved in that countries worldwide would need to bring legislation to treat with the scourge of criminal gangs? Criminal gangs are involved in arms trafficking, robberies, and other violent crime. Drug trafficking, they're involved in drug trafficking, Mr. Vice President. I have before me here an article, and I think the Attorney General spoke about it, 94 million drug bust takes international turn, 8 in custody. This was an article on Loop, 15th of August, 2020, where it indicated that 8 people who were held on Wednesday during a police operation in central Trinidad, which led to the seizure of $94 million in drugs, remain in custody. The article went on to say this is because the shipment is believed to have connections to a major transnational organized drug syndicate with links in the United States, United Kingdom, Canada, and Jamaica. According to reports at 10:30 a.m. on Wednesday, officers of the Central Intelligence Bureau, the Northern Division Gang Unit, the Interagency Task Force, with the support of officers from the Customs and Excise Department and Port Security, intercepted a container at Coolahal Road, Charleville. $94 million in drugs. Mr. Vice President, criminal gangs are also involved in the morally reprehensible crimes of human and sex trafficking. I have another article here. Cop charged with being gang member. Cop charged with being gang member and child sex trafficking. February the 14th, 2020. Police officer Vikash Ramtahal and a Venezuelan national will appear in the Chaguanas Magistrates Court today, charged in connection with trafficking in persons and other gang-related activities. Police officer who is attached to the Central Division has been charged with the following offenses: being a gang member, supporting a gang in the commission of gang-related activity, trafficking in persons, in minors, inciting or causing a child to engage in sexual activity, misbehavior in public office. That is what criminal gangs are up to in Trinidad and Tobago. I want to touch on some submissions from Senator Lutchmedial and as well Senator Leida. Amazingly said that we should have kept special majority provisions in the legislation. And I wonder if the senators are arguing that we as a government should fail in our duty to protect citizens. We should continue, this is what I'm hearing being said, we should continue to bring special majority bills to be defeated by them. And I hear the call by Senator Vieira. And ideally, that is what should happen. Government should work with the opposition as well as the independent senators to put together the best legislation to go forward. But let me tell you why. Because we may have forgotten. Senior members of the United National Congress, as recent as in November and December, have indicated that they will support no special majority legislation by this government. In the Newsday, 22nd of November 2020, Rodney Charles said, opposition will not be supporting any legislation.
Minister, you have a title of the article? Just title for the answer record.
No.
Give it after, that's fine, but just
Yes.
for the answer record.
I have it somewhere, Mr. But on the Newsday, 22nd of November 2020, Rodney Charles said, opposition will not be supporting any legislation which requires special majority. In The Guardian on the 23rd of November 2020, this was by Gail Alexander, the leader of the United National Congress, the member for Separia, indicated no procurement legislation no anti-gang support. We'll isolate you. We will not support you. This was said during a Monday night forum. And in the Daily Express, December the 20th, 2020, no other than Senator Mark said, until the controversial public procurement bill is withdrawn, the UNC will not be supporting any legislation. That is the commitment from the opposition United National Congress. And in going on and commenting on Senator Lochbedial's presentation, it appears as though the UNC keeps moving the goalpost. First, they would not support the legislation in previous incarnations because it infringed on individual rights and freedoms, so they did not support it. And then, of course, and Senator Leida repeated it here today ad nauseum, the resources argument. He spoke about toner, printer, paper, all these matters within the purview of the police, but totally irrelevant to the bill that we are debating here today and the provisions that we need to legislate. Resource argument. And now we also hear that they don't trust the statistics. And Senator Mark spoke about statistics, a lot of statistics. Senator Mark did not say where he got those statistics, but he repeated them. But the unfortunate thing, and this is my belief, that even if between 2018 and 2020, when the previous Anti-Gang Act expired, even if we had 500 arrests and 500 convictions, Senator Mark still would not have supported our efforts here today. Senator Lochbedial said that we're pulling statistics out of the air. Of course, these statistics that the Honorable Attorney General raised are those that come from the police unit that is responsible for collecting statistics. Senator Lochbedial asked, where is the evidence that the legislation is working? And I sat there and I wondered, I don't understand how, if you don't trust the statistics coming from the police service, if you don't trust what the police service is saying with respect to this bill in support of it, how do we prove to the opposition senators that this legislation is working? The goalpost seems to be shifting at every turn. Senator Lochbedial said that it's simply a holding bill. But how do you prove to the senator that persons held under the Act for over 48 hours, for example, prevented massive bloodshed, prevented gang wars from breaking out, prevented criminal activity and violent crime? How do you prove that? But that is what the Commissioner of Police is telling us. And if we're not going to believe the police statistics, if we're not going to believe what the police are telling us with respect to their support and respect to statistics and the merits of these measures, who are we really to believe? Senator Lochbedial even went on to suggest that she does not trust a judge to apply the rules of fairness in an ex parte application.
I must stand up on that, please. Mr. Vice President, that is not what I said at all. Standing order, I'm sorry, I will find it. Because I would like to raise an objection. I did not say that, please, sorry.
Sorry, I didn't get that. Do you have the standing order, yes or no? Continue on.
Thank you very much, because I have to adopt the position of Senator Sagram Suklal. Senator Sagram Suklal went on to correct Senator Lachmidial to suggest that the principles of fairness apply. We cannot ouster the court's jurisdiction. And even though the legislation says that you may make an ex parte application, doesn't mean that the judge has to hear your ex parte application. And the Honorable Attorney General even spoke to habeas corpus applications being made at any time. Mr. Vice President, I move on to the bill. And Part 2, Section 5 of the bill speaks to the offenses, and there is nothing objectionable here. I support fully the Clause 5 of the bill. But I'd like to turn to Clause 6 and Clause 13, which relate to coercing or encouraging gang membership.
Minister, you have 5 more minutes.
Thank you very much. Coercing or encouraging gang membership and recruiting of a gang member. And at this point, I need to support and amplify what Senator Vieira said. Because a gang needs, for its survival, they need to recruit more and more members. They need to recruit more and more turf. It is imperative for gangs to increase its membership, to compete with other gangs, etc., because gang criminality is 95% about profit. It's crime for profit. You need increased membership to increase the strength of a crime, and you need to increase your turf to realize increased illicit revenue. And in the last 5 years, Mr. Vice President, I've had the distinct privilege to serve as the Member of Parliament for San Fernando East. And in the San Fernando area, there are a number of HDC communities. And I went into those communities and immersed myself. You have to get deeply involved with your constituents. And of course, also had interactions with the police. And there was one thing that we uncovered over the last 5 years, that a number of these larger gangs, especially in these so-called hotspot areas, in order to increase their turf, to increase their profits, they would recruit young members in these communities, in these HDC low-income type of communities. And they would give them a pound of weed, or they would give them something to sell, and they would have to return some of the profits to the major gang. And these units, these little gang members in these HDC communities, in conducting their illicit trade, they would terrorize members of those communities. And I also was fortunate enough to sit as a Minister of Housing, and Senator John will know this, that every week you would face a number of requests for persons to be relocated because of the scourge of criminal gangs. We even amended the trespass legislation to treat with that as well, because they would also prevent persons from occupying some of these vacant units. So I support, and I have witnessed firsthand where the police, utilizing the anti-gang measures, have gone into some of these communities and worked to break down the structure of these small little satellite unit gangs. And it goes into Clause 7, retaliatory action, because some of the law-abiding members in these communities, the ordinary citizens, who speak out, who resist these little gangs running around, these young boys, they would have their apartments stoned. They would have their young daughters harassed. They would have violence thrust upon them. So I support Clause 7. And this is the reality. I know that we're talking about concepts of law. We're talking about constitutional matters. But this is the reality that people face while we debate that. These concepts in Parliament, that is the situation that people face. They are prisoners in their own homes because of this type of gang activity. And then, of course, you hear about harboring. And persons from Port of Spain and persons from other hotspot areas come down into the San Fernando area to hide out. So, Mr. Vice President, in closing, I wish to support and commend this legislation to this Honorable Senate. The Attorney General has indicated that he will be making some tweaks, and I welcome and encourage the discussion. Thank you.
Senator Naked.
Thank you, Mr. Vice President. Sorry, I was just musing about how wonderful it must be, or such a liberating feeling to be a white supremacist, or to enjoy the privileges of white supremacy. And I'll tell you why. Thanks for giving me the opportunity to be part of this debate. Because when I looked at the law and researched it, I tried to find some comparative law. Other than the apartheid laws of South Africa, draconian by its nature, I said I will not use that. So I looked again, and you know what I found? I found what were called the Black Codes law, which were actually laws created, and I quote, by southern states even harsher than Jim Crow laws that tried to maintain slavery in the South even after the war. But listen to this part. Black people could be arrested for just about any reason. Restrictive laws designed to limit the freedom of African Americans and ensure their availability as a cheap labor force. Passed by a political system in which black people effectively had no voice. The Black Codes were enforced by an all-white police, and listen to this beauty, and an increasing militaristic force. Wow. Mr. Vice President, if anything, expose it writ large. The difference between that side, the PNM, and the United National Congress, it is this bill. Fundamental philosophical differences. Because we are not against anti-gang legislation at all, as will be stated here repeatedly. We bought it. We recognize it. But what we are against completely is to bring oppressive, draconian laws that infringe on our constitutional rights without, as Senator Vera, and I'll get to him after, without any holistic context. Because when we brought these laws, we had social programs. We had increase in education. We built schools. We provided laptops. So we offered, and then I heard this abysmal reference, as the Minister of Tourism always seems to allude to live sport. And I would like to ask, has anybody been charged, arrested? Or is that just another indication of their failed statistics?
No, they pay 66 billion and a certain proposition.
And nothing?
SRP.
Yes.
SRP.
Okay.
Government police.
Yeah. 66. Yeah, so again, Mr. Vice President, we have a lot of rhetoric on that side, but my concern, as always, is the reality on the ground and the reality of who this bill will affect, which brings me unfortunately today to someone that my elder brother Peter went to school with, which was the Honorable Senator Vera, who I saw today, my brother who, for the last 25 years, he has worked socially in Haiti, helping the disenfranchised there, has his own foundation out of New Orleans. And I'm getting to the point. And I felt that Senator Vera's contribution was quite elitist. And I'll tell you why. To state that...
Mr. Vice President, 46.6 and 46.4, please.
So, Senator Mark, thank you. So, on 46.6, I would just say, just temper a bit what you're saying, right? And I'm going to ask you just for me now to speak up a bit because the mask is really muffling what you're saying, and I'm hearing it somewhat, but like I said, it's coming through a little bit muffled. So just for you specifically, I see Senator Roberts raising his hand, but for you specifically, speak up a bit so that I can clearly hear what you're saying.
I love that. Thank you, thank you. So given that liberal permission, I can be myself. Thank you, Mr. Vice President. And I'll tell you why I felt it elitist. His reference to dogs and sheep and wolves, and referring to obviously people coming from the ghetto as wolves who will be a scourge upon our land. The Honorable Senator not once referenced the gangs that have facilitated these so-called wolves. Because I've never seen a gun-making factory in Laventille or Mondo or places where I have come from. I have never seen a cocaine factory. I have never seen a cocaine factory because I know these young black men do not import the cocaine, do not import the guns. He made no reference to any of the gangs that do and have been doing so for decades with impunity in this country. So I did not like his presentation at all. Because the gangs that run the narcotics and have turned this country into a narco state, oblivious to the destruction caused to this country and to the ghetto youth, that all of us here now seem to want to fit into a penal colony in Trinidad and Tobago. So this P&M government here, with impudence and contempt, let's deal with them on the penal side of things. Well, we know we're not against anti-gang legislation, but we want to deal with it from the other side as well. We want to deal with it where we don't have gangs, when we don't have gangs created. And what is wrong with that? That is why we stress on education. That is why we stress on social programs. So if we want to go into communities and deal with them with our live sport, who we want to affect? So when Jesus Christ came to the meek and the humble and the downtrodden, who he went to? He went to the rich. He went to the elites. But we seem to lose our Christian values quite conveniently. Disingenuous or hypocritical? Choose which one it is. Now, the Honorable Minister of Tourism spoke about that the anti-gang legislation is not to help eradicate serious crimes and it's not to deal with serious. So then what are we coming here for? We want to infringe on people's constitutional rights for littering? for jaywalking. It's either he has a flawed understanding of legislation, or he should stick to standing orders. There's something wrong here. Mr. Vice President, although we can find humor at someone's incompetence, inability to understand what is before us, it's a serious point. And I was not too bothered by the Honorable Minister's contribution at all. I was more concerned about Senator Vera's contribution. Because you see, there's the problem in Trinidad and Tobago right now. And everybody here know by now, I like to deal with the ground. Because I have family who might be affected by this bill. Yes, I have family. Uncle Rudolph Charles, who make despers. As everybody know, his grandchildren still living up in Picton. Uncle Jerry, grandchildren up in Picton, they might all of a sudden be in an area and find 2 guns. Listen, they find 2 guns and playing with it. Are they gang members? Are they prosecuted gang members? Then I know where we could send some of the police, because I saw some pictures of children with guns. We gotta be really careful where we go in here with this one. I hope we go in other than Picton Street. I hope we go in somewhere other than Bagatelle. I hope we go in somewhere other than My Tower, other than in the zone in Tenapuna. I hope we have plenty places we could go. And it's not only black people, children, we coming for with this. So, Mr. Vice President, I come to the anti-gang bill and some of the points that maybe will give the AG food for thought, because the AG normally neat and tidy in his presentation. This is a sloppy piece of work. By his own admission, scrambling before the sitting that this wasn't right or this was this. I mean, come on. The only thing we in here, the doggy, the homework, and I mean, come on. This is the business of the people. This serious legislation here. And to have people who should know better trying to find excuses for this. And I'll tell you what they are. So we have clause 3. What exactly is a gang? Every offense committed as a joint enterprise will qualify whether or not the participants are in fact gang members operating as a gang. This will create confusion in the minds of charging officers and is bound to see a number of prosecutions fail with the usual consequences. Gang-related activity. All of what is described in the definition section is already covered by the common law. And the common law is flexible enough and continues to develop without limiting language of a statute. We don't need it. It's not necessary. All you do is give a greater latitude to infringe on the Constitution. Clause 4. Given what is outlined in Clause 4, I am now completely more confused to what exactly is a gang. What is outlined in Section 4 is wide enough to affect even those groupings which are not gangs and flies in the face of what is stated in Section 3. The words reasonably shows, listen again, reasonably shows in line 5, page 4, according to the bill we have. To what legal standard are we referring? Are we abandoning the criminal standard, which is a protection in itself, and importing a lower standard of proof? Then we go to the words, shall be admissible. Shall be admissible in the very next line. Are we then removing the discretionary power of exclusion from the court and telling the court what evidence is to be admissible? We're saying shall. Shall, as we know legally. I think you're a lawyer. No, you're not. Okay. Don't worry, you're in good company. Telling the court what evidence. Shall means you must, right? Then we go section 4B. Are we creating a new gateway for bad character evidence without regard to what we already have in the Evidence Act, and which was passed with a 3/5 majority? Are we going through the back door and circumventing existing bad character legislation? How will this square with the existing jurisprudence? Okay. I have permission for my voice. Clause 5. Section 5, subsection 1D. So the mere idea, and I want us to pay attention to this. If you all have your papers, look at section 5. This shows such a fundamental lack of understanding of the dynamics of the ghetto. It's unbelievable. Look at this. Section 5, subsection 1D. So the mere idle boast of a wannabe teenager, like all of us were. We boast. That's what we do. We teenagers, we boast. I could do this, I could do that. So a black boy in the ghetto now, he can't dream. I said, no, he can't dream. No, he can't boast. He can't play himself. No, that's not allowed. Not allowed in Lavantil, in Beetham, in Mova.
So, Senator Naked, I know that you were asked to speak up a little bit, but now I'm going to ask you to tone it down a little. All right?
Is it possible that we could get some kind of voice monitor here?
It's actually possible. Please take a seat. It's really possible for someone to speak clearly, articulate clearly without shouting. Okay? And I think the Vice President was asking you because he wasn't hearing you through your mask. I can hear you. There's no need for you to shout. Okay?
Shouting, Madam President.
Senator Naked, please. Please take your seat. I am not asking, there's no need to converse about it. I've given you my guidance and I would just ask you to heed it.
Okay. So, the black boy in the ghetto, not allowed anymore, like any other youth anywhere in the country, to be boastful, to exploit adolescents. So he can't, so, and I'll be even clear. This will land him in trouble now. So if he professes, he want to big himself up, he want to get a girlfriend. So he professes to be a gang leader or a gang member to get some credibility, as they do in any community, in any part of the world. All part of growing up. And he could go in jail for 10 or 20 years. Who conceived this? This is such bad legislation. This is such a poor reflection of what comes before us here, that this is unbelievable. And I go on. Clause 8. I'm going through them. Clause section 8. D. What does provide support mean? A person who knowingly provides support. So, all right, so we have in the ghetto I go up by Uncle Jerry, and I see about 5 or 6 youths, 4 of them cousins, and 1 of them I don't know. Who's the gang member? Uncle Jerry, wife, cook a nice dinner, we eat, talk 2-3 hours. Is that considered providing support? What is the specifications for this? If a mom or dad does that for her son, has his friends over, is this meant, as I said before, in the black codes, in the Jim Crow South, to completely annihilate the black communities? I don't understand. Oh, Madam President, is all of this a political stunt, playing on the emotions of the people in this time to try and embarrass the United National Congress? It would have to be, because it's such bad legislation. I go on, clause 10, section 10, subsection 1B. Who is a reasonable man, or what is reasonable? And Senator Jayanti Lakshmi referred to it. The law is supposed to deal with the actual mental state of the person charged, and not what he ought reasonably to have known. Look at that. Look at it here. And Senator Vera left out that conveniently when he quoted it. I have it marked right here. He quoted the whole thing. He said a person who uses a bulletproof vest, firearm, ammunition, prohibited weapon, on B, has it in his possession, and he left out, and you can go back and he answered, which he ought reasonably to know. He left that out conveniently and went on in the commission of a gang-related activity. You cannot leave out that part, because that there is the devil, which he ought reasonably to know. Who is to determine that? Ought reasonably to know. Shouldn't that be the law? Shouldn't the law charge the court with the mental state of that person, and not up to the discretion of somebody else? Again, wanting on so many levels. Section 10.2 states that a citizen, if he proves it is defense for a person charged with an offense under subsection 1B, if he proves it is a constitutional protection and safeguard that in criminal law, the burden of proof rests with the prosecution throughout. And we've heard this repeatedly here. And what does the other side say? That we protected criminals. We asking someone to prove a negative. So in other words, I could come up to somebody and tell him, hey, you thief my watching. You better don't tell me no. How you going to tell me no? You better prove you and thief that way. But only really cannot more black people in this town. Huh? They're asking somebody to prove a negative. A young black boy from the ghetto, probably barely literate, probably barely knowing his rights, probably no resources to get somebody to come and defend him and tell him to go and prove a negative. And Senator Vera was wrong with that. So Senator Vera liked that one.
Senator Naked, please take your seat. You are very free to criticize any presentation that is made in your chamber. You're free to do that, but you seem to be personalizing your presentation, and I would ask you to desist from doing that. You can criticize, that is your right, okay?
Well, Madam President, I'm guided, but I'm not personalizing anything. I'm responding and rebutting what
I'm
was
not
said.
asking you once again. If I point out something to you, just move on, Senator Naked.
No, because you are not always correct. And I've proven to you that you are not.
Senator Naked, take your seat. You are not in a position, I'm asking you, don't be trying to answer. It's almost as if you're trying to answer what I'm asking you to do. Please, just move on, make your contribution.
Clause 11. Harbors. How does one harbor a gang member if you live in the same compound? Has any of these people gone up to Chumakak? Have they gone up at all to St. Barb's? How these people live cheek by jowl? What are you telling me about harbor? What does that mean? If they live in, you could spit in your neighbor's house. You think they live like you all? Like me? I look outside and I see trees. And so the grandson who living with his grandmother and grandfather, they live in a...
Senator Naked, you have 5 minutes.
They live in a 6x4 here, and just to help the grandson, they put something right next to it. I saw some of you see it all over the place in the camp. He might have an early child, set up something for him right next to it. And they're telling me about harbor. You all make laws without regard for the social conditions of who you are making laws against? Just make laws to impress the public? So, black people, eat that. And we will close our eyes and hope whoever deal with all you, when we open it, all you gone. Love until move out clean and your conscience clear. In closing, I find the drafting of this legislation entirely, completely, catastrophically political in its intent, meant to embarrass the UNC. Nothing else. It's bad law. It's projecting the mood of the country as it is, playing on the emotions of that tragic death of those girls. So let's bring this horrible law. And of course, the UNC will reject it because they've said so. We've had courts. And then we'll say, look, the UNC. They don't care. But this is bad law. Sloppy law by his own admission, the AG. The target is low-lying fruit. Easy for everybody to, don't worry. It's Lavantil, Hightower, the Zone, Bagatelle, Scorpion, no problem. You know why? Because there's a group here, PNM, devoid of ideas to socially and economically uplift the people in these areas. Blackface, white mask, as Frantz Fanon famously said. Thank you, Madam President.
Senator Sipasad.
Madam President, thank you for the opportunity to contribute to the debate on the Anti-Gang Bill 2021. This bill seeks to suppress associations created for unlawful or criminal purposes and for the better protection of the public of Trinidad and Tobago by making it an offense to be a member of a gang, be in possession of a bulletproof vest, participate in or contribute to any gang-related activity, support or invite support for a gang, or to harbor or conceal gang members, or to recruit persons to a gang. Clauses 5 through 14 of the Act proposes severe penalties for specific gang activities. The intent is to be a deterrent to gang membership and activities. However, in the absence of a comprehensive social and economic undertaking to offer superior alternatives to the young, underprivileged, and disadvantaged for opportunities and survival, I have serious misgivings that this piece of legislation will have the intended outcome. It really seems as though gang-related activity is embedded in our very fabric or DNA of our culture. The novelist Earl Lovelace in 1979 captured the essence of the modern-day description of street gangs in his book, The Dragon Can't Dance. He wrote, "Those were the days when every district around Port of Spain was its own island, and the steel band within its boundaries was its army, providing warriors to uphold its sovereignty. Those were the war days when every street corner was a garrison, and to be safe, if you came from Belmont, you didn't let night catch you in St. James. If your home was Gonzales Place, you didn't go up Laventille, and if you lived in Morvan, you passed San Juan Street," end quote. Gang-related legislation was, and I quote from the Trinidad Express, November 21st, 2020, first introduced by the People's Partnership Government in 2011 and later resurrected by the PNM administration in 2018. Anti-gang legislation gives the police service extraordinary powers to combat the scourge of gangs. Through their MPs, the public agreed to temporarily surrender several basic constitutional rights to allow the police to prosecute and convict gangsters. In succession, the partnership and PNM governments received public and parliamentary support by successfully arguing that a suspension of constitutional rights would allow the police to eradicate gang-related crime. Under the People's Partnership Government, almost all the cases filed under the Anti-Gang Act 2011 stemmed from the 2011 state of emergency and were thrown out by the court. In the case of the PNM, there is equally little to show after 2 years. The law has simply not lived up to the hype to date, end quote. In February 2019, the Trinidad Guardian newspaper reported, based on statistics from the Trinidad and Tobago Police Service, that gangs are a problem. And according to the statistics, it's a growing one. In 2006, there were 95 gangs with 1,269 members. In 2016, there were 172 gangs with 2,358 members. The most recent report indicates that there are 211 gangs with 2,458 members. The gangs are littered across the islands, with Rasticity and Muslim being prominent. Before 1990, there were few gangs, which have now escalating to this seemingly uncontrolled position. As the gangs escalated, so did the gang-related crime, with the murder rate increasing from 4 in 2000 to almost 300 today. Between 2018 and 2020, there were 36 arrests for gang-related offenses. Madam President, that is the reality. Most commentators on several media platforms ask rhetorically if Trinidad is a real place, because our collective approach to national problem solving is pitiful. So why do we really need this anti-gang legislation? There are other laws on the books which can be energized, including Evidence Amendment, Civil Assets Recovery and Management Agency, Evidence Act, Bail Act, and the Firearms Act. Are these laws deficient and ineffective? Police detection and conviction rates. The detection rate increased from 10% in 2018 to 20% in 2020. However, the conviction rate remained at about 1% for the period. Data from the Crime and Problem Analysis Department of the Trinidad and Tobago Police Service show that between 2000 and 2020, only 291 persons were arrested under the Anti-Gang Act. Madam President, as I've said before, a plethora of laws by themselves will not dent the scourge of criminal activity. The Honourable Attorney General has listed in this chamber that many initiatives and pieces of legislation for which he is bringing to Parliament. But to what end? What is the true measure of success? Is the nation better off because of these laws? International Women's Day yesterday reminded me of the horrors and heartbreak plaguing this country, despite the best efforts of all. You see, Madam President, we need societal transformation as well as laws. The root cause of the problem is the day-to-day hell of the uneducated, underprivileged, disadvantaged, jobless citizens. This Frankenstein is of our own making over time, and putting the monster back in the bottle does not need more thuggery. Forensic evidence system. Forensic evidence is crucial in criminal justice systems to build cases and support convictions. However, the forensic evidence system in Trinidad and Tobago is not up to standard, despite attempts to improve the system. For example, the Trinidad and Tobago Ballistic Recovery Department opened in January 2021. The Evidence Amendment Bill was passed in February 2021. Evidence collections by the Trinidad and Tobago Police Service and analysis by the Trinidad and Tobago Forensic Science Center is plagued by systemic issues. This contributes to the low detection and conviction rates, as well as the backlog of cases in the judicial system. What about prevention, Madam President? Do we wring our hands in unspeakable agony every time a monster strikes and wait on law enforcement to solve or not solve the crime, as is more often the case? The DNA laboratory at the Trinidad and Tobago Forensic Science Center has been closed for the past 2 years. While the personnel with the requisite expertise are available, they cannot work until repairs to the lab are done or a new building is constructed. Therefore, until a few weeks ago, DNA evidence was sent to the United Kingdom for testing at a cost of hundreds of thousands of dollars per test. It has now been decided to use a private laboratory in Trinidad and Tobago to do DNA testing. There's also a lack of a robust DNA database and forensic evidence system. This means that the police rely primarily on eyewitness evidence with very little reliance on forensic evidence. There's also a lack of adequate financial resources allocated to the Trinidad and Tobago Police Service for the collection of evidence. Between 2005 and 2010, full-time crime scene investigators were recruited from the UK to train and mentor TTPS officers. However, issues... Sorry.
I just need to ask you, you are giving a lot of information about the entire criminal justice system, about all sorts of things about crime, but I need you to be a little more specific to the bill as well. Okay, so whatever you are saying, you need to tie it in to what we are treating with.
Points?
But no, just tie in whatever you are presenting to the bill at hand.
Okay. Section 3, definition of a gang. I find that the definition of gang is insufficient. In my research, I found the definition of gang used by the U.S. Department of Justice and Department of Homeland Security's Immigration and Customs Enforcement, which I believe is more robust. And I'll give the quote. And it says, 1, an association with 3 or more individuals. 2, whose members collectively identify themselves by adopting a group identity, which they use to create an atmosphere of fear or intimidation, frequently by employing one or more of the following: a common name, slogan, identifying sign, symbol, tattoo, or other physical marking, style, or color of clothing, hairstyle, hand sign, or graffiti. 3, whose purpose is in part is to engage in criminal activity and which uses violence or intimidation to further its criminal objectives. 4 whose members engage in criminal activity or acts of juvenile delinquency. The association possesses characters such as they employ rules, recruit members on a regular basis, provide physical protection, etc. Madam President, this matter can be further discussed at the committee stage. Section 3, definition of gang-related activity. D, conspiracy to commit an offense. A charge of conspiracy means that there are multiple defendants in the same indictment. Each person is therefore tried together in one joint trial. The advantage of this is that multiple people who may have different levels of criminal responsibility in the case are all grouped together, with the danger that the jury may amalgamate the evidence and say that they are all equally guilty. While the judge will instruct the jury to consider the evidence individually against each defendant, the danger of amalgamation of evidence is always present in joint trials, with multiple defendants charged in the same criminal act. I would be grateful if the Honourable Attorney General can provide an explanation of how conspiracy to commit an offence will be applied in the Trinidad and Tobago courts. Powers of Police, Section 15 and 16. Clause 15, police powers of entry, search and arrest. Powers to enter someone's property on a reasonable belief that the person is a gang leader or gang member. Clause 16, detention of persons. To detain a person without a warrant for 48 hours, with a further 36 hours allowed. Madam President, as of December 31st, 2020, the Police Complaints Authority had 3,876 complaints against the police. 3,259 investigations were completed, and 77 matters were sent to the DPP. In the Trinidad Guardian article entitled PCA Probes 3,876 Complaints dated March 6, 2021, I quote, "The AG acknowledged that the country is properly dissatisfied that there are concerns on police killings, shootings, and people dying in police custody. In the past 3 years, there have been several investigations into the deaths of Trinidad and Tobago citizens in the hands of the Trinidad and Tobago Police Service. Most of these complaints have been completed by the Police Complaints Authority, which recommended prosecution of the police officers. There are, however, several cases which were closed on the recommendation of the Trinidad and Tobago Police Service legal unit without the input of the DPP. Madam President, it appears that the police are using brute force to extract information from people instead of getting hard evidence. Further, any member of the police service, based on these sections, including a constable, will be given significant power. The powers provided by these two clauses promote profiling of people and give the police the wherewithal to detain and search people's property without a warrant. There are fundamental constitutional implications, Madam President. We should not implement these measures without first safeguarding the fundamental rights of citizens. Search on suspicion alone is not due process and leaves abundant room for victimization and abuse. Madam President, I'm uncomfortable with giving the Trinidad and Tobago Police Service carte blanche powers to search and arrest based on the belief that the person is a gang or gang member. Witness protection in Trinidad and Tobago. This is a key component to Section 7 of the Anti-Gang Bill. Data from the Trinidad and Tobago Police Crime and Protection Branch shows that between 2011 and 2020, 4 state witnesses were murdered. Is the program safe, or is it that these murders are a result of witnesses being careless and not agreeing to participate in or follow protocol? In the article entitled State Witness Worry About Safety, Trinidad Guardian, February 25, 2021, a state witness said, "I told them what the officers were capable of. I brought my fares to them and they took my information, and the officers came and locked me up. The system failed me from day one. The system, I'm not getting work because people are afraid to employ me because of the risks, and they keep telling citizens to come forward every day. For the system to be effective, witnesses need to have confidence in the criminal justice system so that they can provide evidence against criminals and join the witness protection program. State witnesses need to be assured that they will receive all the support and protection that they need from the criminal groups seeking to prevent them from cooperating with the authorities. As our crime figures has escalated, an entire generation have grown up facing decayed or decaying infrastructure, parenting challenges, household and community violence, incomplete education, substance abuse, mental health, unequal education opportunities, to mention a few. Prevention strategies based on sound social and social psychological research and programs may have prevented some of this. Unfortunately, what is now referred to as social protection includes stopgap measures, primarily of cash transfers of various forms, food cards, grants, short-term work. While it's important in the short term, it is not adequate in the long term. I do not think we can easily eradicate the scourge of illegal gangs and criminalities with only the anti-gang legislation. We need social input. Short-sighted, get tough measures only play into the gang's favor to be more organized. Preventive measures, social intervention, and suppression are essential. Gangs bring guns, strategy, technology, and community support due to the fear that they bring to the communities they control, which the state does not provide. By itself, severe penalties and constitutional subversion proposed by the anti-gang bill will not be a deterrent by itself. Thank you, Madam President.
Leader of Government Business.
Thank you very much, Madam President. Madam President, I beg to move that the Senate do now adjourn to Tuesday, March the 16th, 2021 at 1:30 p.m. During that sitting, we plan to conclude the debate on this anti-gang bill.
Honourable Senators, before I put the question on the adjournment, leave has been granted for two matters to be raised. Senator Mark.
Thank you, Madam President. Madam President, I have raised a matter on the motion for the adjournment in the public's interests, and that is the need for the government to explain the benefits of the recently signed Memorandum of Understanding involving the National Gas Company, the National Energy Corporation, and Kenneth J. Green Limited for the development of a national policy framework for energy efficiency and green hydrogen. Madam President, Trinidad and Tobago awoke to a full-page colored ad plastered on page 11 of the Trinidad Guardian of Thursday, February 11th, 2021, with a screaming headline which stated, and I quote, NGC and the National Energy Corporation signed MOU with Kenneth J. Green and Nugent. Subtitle, Moving Hydrogen Energy Forward. Now, Madam President, this reminded me of WGTL all over again. But in 2004, it was known as the Bridge to Hydrogen. In 2021, the title is Moving Hydrogen Energy Forward. The only difference, Madam President, the same players are involved. Some have retired, but their siblings are in charge. So this is a matter that we want some clarification on. When we look at the directors of these companies, they are the same players. Kenneth J. Systems Limited, you have Philip Julian. You go to Kenneth J. Green, Philip Julian. You go to Nugent Energy, Philip Julian. Same players involved in this game that we are witnessing today, Madam President. And when you look at the shareholders, Madam President, again, it's the same players who own and control the particular companies that I've mentioned. Madam President, time wouldn't permit me to really spend the quality effort at sharing with you and the population what this thing is all about. What we do know is that this Kenneth J. Green went into some relationship with Kenneth J. Systems and Nugent Energy. And at the end of the day, Madam President, a big advertisement, the National Gas Company that is leading this charge, along with the National Energy Corporation, never told this country once that there was a company called Ministerial Energy, a Spanish company that was involved in this transaction. That is why we found it very suspicious. And we have brought this motion today so that the government can clear the air on this matter, because I don't think that the people are ready to stomach or will ever be ready to stomach another WGTL, which cost this country over 2.5 to 3 billion TT dollars. Therefore, Madam President, I would like to ask the Minister of Energy to answer these questions. First of all, this full-page colored ad, which appeared on the 10th, 11th, and 12th in the 3 daily newspapers, could the Minister indicate who paid for that? We would like the Minister to tell this Senate today whether the chairman of the National Gas Company is conflicted, because there's a Philip Julian, there's a Stephen Julian, and there's a Conrad Enel. Is there a relationship between the three? And if there is, Madam President, I would like to ask the Minister to tell us if, as far as he's concerned, when the so-called Memorandum of Understanding was being agreed upon, whether the chairman of the NGC recused himself. Madam President, we would like to know whether this so-called project consultancy were publicly tendered, and if not, why not? Why did the NGC and the NEC how did they come into contact with these 2 privately incorporated companies? Madam President, one of them was incorporated in January of 2020. The other one was incorporated in July of 2020. What is their track record? What is their capital base? What is their experience? But they are in the dance with the National Gas Company. I understand the National Gas Company has cash reserves of about $6 billion. So not satisfied with destroying the Petrotrin with this WGTL, Madam President, I want to let this Senate know that it was the $850 US bullet payment that was borrowed by Petrotrin on behalf of the World GTL project that had Petrotrin on its knees and that caused the government to close down Petrotrin. So we would like to ensure that NGC does not become another Petrotrin. And could the Minister of Energy tell us about Fisteria Energy? Could the Minister indicate whether NGC will be building the hydrogen plant on behalf of these two companies that I have mentioned? And I also would like the Minister of Energy to tell this Senate, is the National Energy Corporation's mandate not include renewables and the development of hydrogen production? If that is so, Madam President, why is the NEC not developing this hydrogen project? Is the NEC not capable of pursuing this project? But they have the skills, they have the personnel, they have the employees. Why are they not pursuing it? I would like the Honorable Minister to indicate, Madam President, why did the National Gas Company in these three fully paid, full-colored ad did not tell the country that there was a company called Fisteria Energy that was involved in this exercise and this project? Madam President, we would like to know whether the NGC was apprised of a partnership between Fisteria Energy, SLU, and Kenny J. Green Limited to pursue this first major hydrogen project known as NewGen. And Madam President, I want to ask the NGC and the NEC must take full responsibility along with the Minister of Energy and the Prime Minister. Don't tell this country that the Prime Minister, who is the chairman of the Energy Committee of the Cabinet, did not know about this situation. So we want answers this evening on this emerging scandal that may result, Madam President,
Minister of Energy and Energy Industries.
Thank you very much, Madam President. Madam President, I should start by saying, there he goes again. Every time this administration takes a step forward, the UNC, and in particular Senator Mark, tries to lasso our neck and pull us back 2 steps backwards. Madam President, first and foremost, what the Memorandum of Understanding the NGC signed with Kenneth J. on the 29th of January 2021. The MOU is a non-binding and non-exclusive and seeks to explore potential areas of cooperation among the entities for the development of hydrogen. Plain and simple, a non-binding Memorandum of Understanding for potential cooperation. The Kenneth J. Fisteria project was already outlined by the companies at the Energy Conference held a month or so ago. But you see, when we move forward, the UNC insists to politicize everything and move us backwards. It happened with Dragon. It happened with Lauren Manatee. It happened with Sandals. And every time we put forward an idea to this country, it meets with criticism. Let me explain hydrogen briefly to the Senate. In particular, the scientists among us, Senator Timol and others. The hydrocarbon industry is by definition hydrocarbon. What does hydrocarbon mean? Hydrogen and carbon. Natural gas is CH4 chemically. One atom of carbon, 4 atoms of hydrogen. The industry uses the hydrogen as fuel. So what you do, you split the molecule, extract the hydrogen, and it releases carbon dioxide as a byproduct. Carbon dioxide is a greenhouse gas. So the world is moving away from greenhouse gases. So that is why they seem to be migrating into what they call a zero carbon world, away from hydrocarbons. We don't need the carbon in the hydrocarbon, we need the hydrogen. What is the formula of water? H2O. What you can do is use electrolysis to split the water molecule, get the hydrogen, and oxygen is a byproduct. That is what clean energy is about. This country was one of the first countries in the world to have all its electricity powered by natural gas. This country was one of the first countries in the world to take natural gas, monetize it through the production of petrochemicals. We were the third country in the world, after Qatar and Indonesia, to get into LNG. When we built the Train 4 plant, it was the largest single train of LNG in the world. When we built the M5000 plant in Point Lisas, it was the largest methanol plant in the world. We are pioneers in this industry. And what we are doing now, we are attempting to get into the new industry of the zero carbon world, hydrogen. I just want to read an article here from World Oil. Saudi Arabia takes steps to lead the 700 billion, hear the figure, 700 billion global hydrogen market. And it goes on to say, and I quote, Madam President, sun-scorched expanses and steady Red Sea breeze make the northwestern tip of Saudi Arabia prime real estate for what the kingdom hopes to become, the kingdom hopes will become a global hub for green hydrogen. But to produce green hydrogen, you cannot use electricity from natural gas. You must use renewable energy. That's why we're going into solar. And that solar power will be used, hopefully, when the time comes with whosoever the investor is, to produce the green hydrogen. Saudi, the king of oil, is going to spend billions of dollars to develop a peninsula in Saudi Arabia with solar power to capture the 700 billion emerging global hydrogen market. The world is not sitting down and waiting on Trinidad, you know. If we don't get up and get conscious of what is happening, we will be left behind. But one thing I can assure you, we will not be left behind with the UNC. We in the PNM, we are proactive. We see where the new industry lies. We have to transform, as you're saying, we have to pivot. And we have to go with the global trends. We lived a happy life on the hydrocarbons, and hopefully we will continue to for a while. Because luckily for Trinidad, natural gas is now considered the transition fuel. It is the cleanest of the fossil fuel, but it is still a fossil fuel. And a transition fuel, by definition, means what? You're transitioning into something. You're transitioning into a zero carbon world. BP and Shell have already said they will be net zero carbon emitters by 2050. Europe has taken the same trajectory. Under President Biden, the US has taken the same trajectory. So we just cannot sit down here as morons and think the world will wait on us. And if we go to listen to Senator Mark And if you go to listen to the UNC, where they see politics and scheming in every single initiative of the government, we will go nowhere. So this motion, Madam President, is a non-motion, like most of the motion that he has brought. But it gave me, as the Energy Minister, the opportunity to outline to the public the foolishness that Senator Mark has come to the Senate here today. And I hope I have elucidated the population as to the merits of the projects like these. I thank you very much, Madam.
Senator Dana Ryan.
Thank you, Madam President, for allowing me the opportunity to raise this matter. The need for the government to publish a 3 to 5 year economic sustainability plan to strategize for the continuous shortfalls in fiscal revenues and worsening debt trajectory since the onset of the COVID-19 pandemic. Madam President, since the onset of the COVID-19 pandemic, we are faced with a situation where the already worsening fiscal and debt part of the last decade is being exacerbated. Government revenues and public sector debt is taking a hit to ensure macroeconomic sustainability is preserved. Recent publication from the Ministry of Finance showed that fiscal revenues, after falling short of projections in fiscal 2018 and to 2020, the first 4 months of fiscal 2021 have recorded a shortfall in revenues of $1.8 billion. This shortfall, if conditions responsible persist, could result in a further shortfall in revenues of $5.4 billion to the already budgeted deficit of $8.2 billion for fiscal 2021. What this means is that our ability to meet our targets established in the fiscal package 2021, such as to reduce the overall deficit from 11% of GDP to 5.6% of GDP, to meet our ambitious debt-to-GDP ratio target of 65% by 2023 to 2024, and attaining a primary fiscal balance in 2021. Now, in order to maintain fiscal and debt sustainability, it has become necessary to clean up the inefficiencies that has been festering for decades, resulting in leakages that are no longer affordable. In trying to get a hold of the situation, the government has begun the introduction of a cocktail of adjustment measures simultaneously. We are all aware of them, such as the rationalization of WASA, elimination of fuel subsidies, and so on. The end result is that the public at large is having to accept a decline in will eventually have to accept a decline in disposable income to the already stagnant if not declining incomes. As a result, it is important that we present the population with a comprehensive fiscal plan, economic sustainability plan that covers the next 3 to 5 years. In order to be fiscally responsible, there is a need to look more carefully beyond the annual time frame using econometric forecasting methodologies to determine whether the decisions made today will be sustainable in the future, but also to ensure that the government can better be prepared to cushion the potential impact of crisis and react to them in an affordable, sustainable manner through fiscal stimulus if necessary. Without such a plan, there is a risk of overcommitting or even undercommitting our resources. And that could further jeopardize our debt, fiscal, and external position. The plan I am asking for, Madam President, is commonly referred to as a medium-term fiscal framework. It goes beyond the work of the Economic Recovery Committee. It is a framework for setting multi-year fiscal objectives, which will then be a reference throughout the budget period. It outlines the macroeconomic environment, the government's midterm resource envelopes, its fiscal position, projected debt levels, and financing requirements. For example, making it a continuous exercise to analyze the link between macroeconomic forecasts and revenue forecasts using elasticities to explain how a change in GDP forecast will translate into a change in our revenue forecast. To be able to have a sensible picture of the macroeconomic and fiscal environment in the medium term, the government needs to work on and develop macro fiscal forecasting skills to plan for the next 3 to 5 years. That is, estimation of high-level macroeconomic fiscal indicators, such as GDP growth, inflation, employment, unemployment, interest rates, commodity prices, government revenues, government expenditure, fiscal balances, public debt, taking into account what the fiscal deficits imply for the change in debt going forward, as well as the debt servicing costs or interest expense. Madam President, we need a plan which first set realistic macroeconomic forecasts and a set of medium-term projections. 2, we need to provide explanations why the proposed fiscal path is sustainable. Often longer-term debt projections can provide such assurance. 3rd, complementing these figures with alternative scenarios or sensitivity analysis can help better take uncertainty into account. With revenue projections, Madam President, we would need to include a fiscal rule or objective. For example, suppose we want to achieve a balanced budget by 2025. Madam President, this would allow us to determine the expenditure ceiling for the next couple of years, allowing us to properly assess fiscal space available to fulfill the mandate of the government. This could come from the Vision 2020 overarching document, the plans from the Economic Review Committee, or whatever reprioritized policy objectives the government may have. In closing, Madam President, the foundation of our economic recovery is contingent upon fiscal management beyond the annual budget cycle. Without this, we would continue to shift the goalposts to achieve economic diversification. I thank you, Madam President.
Minister of Finance.
Thank you, Madam President. First, let me correct some misconceptions which may have inadvertently crept into the discussion. If one looks at the Review of the Economy 2020, and in particular Appendix 22, it is not correct that there is a continuous shortfall in fiscal revenues. There was a decline between fiscal 2016 and fiscal 2017 from 44.9 billion in fiscal 2016 to 36.2 billion in fiscal 2017, and that was occasioned by the precipitous decline in oil prices in particular, and also natural declines in oil and gas production, as well as a gradual decline in the price of natural gas fetched by our natural gas. However, by fiscal 2018, the recovery had begun with an increase in revenue from 36.2 billion in fiscal 2017 to 43.2 billion in fiscal 2018, rising again to 46.7 billion in fiscal 2019. What this means, Madam President, is that the revenue, government revenue in fiscal 2019 was more than fiscal 2017, 16, and 18. There was an upward trajectory. What has happened in fiscal 2020 and continuing into fiscal 2021 is COVID-19. And there are some commentators in Trinidad and Tobago who seem to want us to believe that it doesn't exist. So I would like to refer to, because it's easy to be academic with respect to these matters, but this is not the time for academics. Let me read from a December 2020 article written by the PES group in the European Committee of the Regions. And in that, they quote the Minister, President of Belgium, making the statement: the COVID-19 crisis has created an unprecedented economic, social, and budgetary tsunami. Citizens in the EU are suffering terribly from the pandemic's consequences. Our wish is thus that the European economic governance is reviewed and adapted to our territories and regions' realities. Once the pandemic is under control, we cannot go back to the ex-ante status quo, nor continue as if nothing happened. And the article goes on to say, I'm quoting now Elio Del Rupo, this opinion puts an emphasis on the fact that a member state in recession cannot be forced to reduce its spending at the risk of further aggravating the recession. And there is a severe warning if you read all of the learning in recent months, over the last 3 to 4 months. There is a serious warning that the worst thing a country could do, particularly a developing country such as ourselves, is to engage in an austerity program, because we may very well get a double dip recession. I would also like to read from a paper by UNCTAD. It reads as follows, September 2020. UNCTAD warns of a lost decade if austerity becomes country's winning policy mindset. And what this paper tells us is that a lost decade, another lost decade, is not inevitable unless we make the correct policy choices. An inclusive and sustained recovery will only happen if governments in the advanced countries not only keep spending for as long as it takes for their own private sector to regain the confidence to spend themselves, but also extend financial support to help developing countries tackle the underlying stresses and fractures holding back their recovery as a result of the pandemic. The point is, Madam President, we do have a medium-term macroeconomic fiscal policy framework. We've always had one, and we revise it every 6 months. However, in the face of the economic wreckage of COVID-19, the programs of the past, such as devaluation, reduction of public sector spending, retrenchment, removal of subsidies, whole-scale removal of subsidies, those failed policies that were attempted by another government many years ago, are no longer relevant. I have no problem whatsoever in publishing, and the government has no problem whatsoever in publishing the current 3-year macroeconomic framework and our economic recovery plan. I have no problem whatsoever. But I want to stress that some of the ideas that are being promoted in the media, in the university, and even in here, Madam President, will simply cause our economy to go into a tailspin from which it will never recover. All over the world, developed countries, the United Kingdom, if one had been following the Chancellor of the Exchequer in the United Kingdom debt to GDP ratio is now over 100%. It is the highest it has ever been for the last 70 years. And it was at that level because of the Second World War, because they had to spend to come out of the issues from the Second World War. We are in a situation where it is our view that we must spend our way out of this recession. And the old metrics of debt to GDP ratio and debt as a whole are no longer applicable. So I will be very comfortable and happy to publish our 3-year macroeconomic medium-term framework for the benefit of honorable senators. But certainly what we will not be doing is following the advice of academics who tell us that the only solution is devaluation, retrenchment, and recession. I thank you, Madam President.
Honourable Senators, the question is that this Senate do now adjourn to Tuesday, March 16, 2021 at 1:30 p.m. Those in favour say aye. Those against say no. I think the ayes have it. This Senate now stands adjourned to Tuesday, March 16, 2021 at 1:30 p.m.